So can we begin?
Yes, Jay, let's do that.
Hello and welcome, and a very warm welcome to everyone, all the distinguished resource persons and the participants who have registered for this particular workshop. So friends, at the outset, this workshop is jointly being conducted by CEERA National Law School of India University in collaboration with NPTEL. Now, this workshop on critical natural resources, exploration and exploitation policy aims to delve into the strategic, scientific, and policy dimensions of managing critical resources. Now, as we all are aware that the global demand for these finite resources intensifies, especially in the context of energy transitions, technological developments, and geopolitical competition, the aim and objective of this workshop brings together experts to discuss sustainable approaches to exploration, exploitation, and governance. So with a focus on minerals, energy resources, and ecological sustainability, the workshop aims to equip our participants with interdisciplinary insights at the intersection of policy, science, law, and economics. With this, I once again welcome everyone to the workshop, especially our esteemed speakers for the day, beginning with Professor Dr. Sairam Bhatt, Professor of Law and Co-Director, CEERA National Law School of India, Bangalore. Next, we would be joined by Professor Dr. Kirk W. Hunker, who is a Professor of Law and Vice President for Sustainability, Faculty of Law, University of Cologne, Germany, Advocate Raghav Parthasarathy, who is a practicing advocate at Bangalore and a research scholar at the Gujarat National Law University, Gujarat. Dr. Vidya and Jacob, Associate Professor, School of Law, Christ, deemed to be University, Bangalore. Dr. Gayatri D. Nayak, Assistant Professor, National Law School of India, Bangalore. Mr. Sanjay Shenoy, Advocate, High Court of Kerala. Dr. Mrinalini Shinde, Assistant Professor, NLU, Orissa. Ms. Nabila Siddiqui, Assistant Professor, Vinayak Missions Law School, Chennai. Dr. Veena Roshan Jose, Assistant Professor, MNLU, Nagpur. Dr. Shivendra Rahul, Assistant Professor, MNLU, Nagpur. Mr. Vikas Gehlot, my esteemed colleague, who is a research associate at CEERA-NLSIU. Mr. Divyanshu Priyadarshini, Assistant Professor at Department of Law, Vishwakarma University, Pune. And our international resource persons who would be joining us in some time, Professor Patricia and Professor Admola. With this, I request Professor Sairam to please begin the first technical session of today's workshop. Over to you, sir.
Thank you, Jay. Ladies and gentlemen, let me welcome my colleague Gayatri Girish, who is also an esteemed member of CEERA, and all the CEERA members who are here helping us organize this workshop, and also thank NPTEL for hosting this workshop. At the outset, friends, I just want to lay down why this workshop, right? Uh, Very often than not, we fail to address an issue about why this discussion on natural resources that we should do at this point of time. So the answer to this, friends, is, we talk about natural resources in various forms. How many of us, and please use the chat box because, I'm going to be a little, trying to guess what you all know about natural resources. So I hope all of you will participate with me so that we'll be able to learn in this 5 hours. Okay, so this is a 5 hours workshop, and Jay has designed a test at the end of it. So we must test our knowledge. We must test our takeaways and learnings, isn't it? So how many of you know the distinction between natural resources and biological resources? Because this workshop is about critical natural resources. And the word critical is something that we'll have to probably define at some point of time, but we understand critical natural resources are those that are very relevant to the times that we speak about. So as soon as I said about biological resources, I had Divyanshu who switched his video on. He said, "Sir, this is my area of interest. So can I answer?" Divyanshu, I know this is something that you will be very eager to contribute, because Divyanshu worked with the UNDP project when we launched the same under the Biodiversity Act. How many of you, chat box is open for interaction? Friends, let's learn the law. Is coal a natural resource or a biological resource? Raghav is also here. So it's the entire, we are like an abuse of dominant position by the CEERA team now. Anyone apart from the CEERA team, the difference between biological resources and natural resources. This seminar is not about biological resources. This seminar is only about natural resources. Yes, good, good, good. Come on, guys. Yes. Natural are what human finds useful. Okay. Biological resources are more useful than natural resources. Coal is a natural resource. Okay, good, good, very good, very good. Yes, coal, oil, and natural gas or gas in the LPG form. All these are natural resources. Okay, I hope yes, yes, derived from the earth. Natural resources are derived from the earth. Biological resources are derived from atmosphere, outer space. No, just asking curiously. So I thought I should start with something that will encourage you to be interested, glued to the next 5 hours. Do you understand this? Sun is natural resource. LG Patel. Sun is a natural resource. Okay. So, friends, I hope you understand this distinction because I have a very interesting statement to make. I have to say this, and this is very very important. I think natural resources may contain biological resources, but biological resources are not natural resources. Am I right in saying so? Shall I repeat? Natural resources may contain biological resources, but biological resources will not contain natural resources. We are lawyers. We are very good at convincing and confusing you at the very beginning of a workshop. So, friends, anyway, the point is this: that why are we talking about natural resource exploration or production or exploitation or the governance system? How many of you think that at this juncture, as we speak today in 2025, while we are talking about making India a Viksit Bharat by 2047, a developed economy in the next 23 years or 22 years, uh, is natural resource important to make us a developed economy? Is the governance of natural resources important to make us Viksit Bharat? Answer. Use the chat box, friends, please. I want your participation. I want you to, say yes, no. You may say, sir, we can do without natural resources. We may become a developed economy without natural resources. Friends, I call natural resources as wealth of nations. Nations build their wealth based on the wealth of natural resources. If you are rich in natural resources, the nation is also rich. If you're bestowed with natural resources, the nation automatically becomes rich. So, friends, India typically is a nation that has to develop, the system of governance of natural resources. Because, friends, please note, I believe that we are right now changing the governance system of natural resources. Rather, you will see the shift of governance of natural resources. What was there a few years back and what is going to be the future of natural resource governance is shifting, it is changing. Yes, it is. For example, friends, if I ask you today, when we exploit natural resources, would we be concerned about indigenous community or tribal rights? Will we be sensitive towards their rights before we explore natural resources? Yes or no? We should. We are. We will. What is the answer? Friends, after the enactment of the Forest Rights Act of 2006, this one law has given tribals, we have to say scheduled tribes and other forest dwellers, the right to decide development, exploration and exploitation of natural resources within their communities. And in a fantastic judgment called the Niyamgiri case, the Supreme Court has established this right, where the tribals or the indigenous communities can decide whether a natural resources like bauxite in a particular tribal area can be exploited or not. And hence, friends, please understand the governance system is undergoing reform. It is undergoing change. It is undergoing what I call as social transformation. And it is important for us to evaluate that social transformation. It is important for us to assess that social transformation and also judge whether it is good, bad, or ugly. So, can natural resources be exploited at the cost of the rights of indigenous communities? Rather, let me ask you this: should natural resources be exploited at the cost of indigenous community rights? Yes, no, don't know. Afternoon session, you must participate.
No, sir. No, no.
No. But can it be just no, or should it be a balancing of the rights of resource requirements and the rights of the tribals as well? So is it no to development? Is it no to natural resource exploitation? Or is it balancing of rights between the tribals and their need to protect natural resources and their community, but also the nation's requirement? Because please note, you're not going to be a developed country or a developed economy if you don't rely on your natural resources. So the word called sustainable development as we speak in natural resource governance has to be defined. Sustainable development of natural resources has to be defined. So I believe, friends, the timing of this workshop is very critical. It's very important because remember, we call natural resources. Resources are for use, but not abuse. They are for use. It is for the benefits of the people. It is for the benefit of the country. But at the same time, friends, when I start exploiting natural resources, do I do it in a sustainable manner? And how do I define that sustainability? Point one. Point two, how do I protect the interest of the current generation to use these natural resources while balancing the interest of the future generation to also have access to the same resources? So sustainability and sustainable development of natural resources is inevitable in the current context. And I think we are at the level of where governance has to be redefined. It has to undergo social transformation. Second, friends, very importantly, should natural resources be exploited nationally by the central government? Should state governments have a right in the same? Or should local participation also be there in natural resource governance? Friends, states like Jharkhand and Chhattisgarh may have abundant sources of some natural resources, but are they reaping the benefits of the resources in those states? Is the benefit of natural resources exploitation percolating to the local communities? Are they getting benefits of the development overall that happens in the nation? So can you look at local participation, local development, the rights of local communities as their first right over the natural resources that are used? So what we call as stakeholder involvement in natural resource development, or what we call as community participation in natural resource development, I think is a very important factor that has to come into the governance model. So the question to all of us is, should we look at centralization or decentralization of governance? And please note, it need not be, overall, but it can come down to certain specifics of, say, which kind of resource are we speaking of. So, friends, I have one more question to all of you because I'm laying down just the kind of agenda for this workshop. As I said, that there is going to be a, we are looking at social transformation in the natural resource governance. And we don't have an overarching law like New Zealand has called the Resource Management Act. We don't have an overarching law like a law that can look at principles of resource management. Let me just ask you, are we at a stage where conflicts and litigations are rising in natural resources? I repeat, are we at a stage where conflicts and litigation on natural resources is increasing? It could be the recent judgment of the Supreme Court, which is given by 9 judges about royalty versus tax. It's a recent judgment. Please note it down. If some of you are interested, you should read it. And some of our speakers, I'm sure, will be referring to this judgment. So are we looking at conflicts? Are conflicts increasing in natural resource governance? Are litigations increasing in natural resource governance? Friends, from our limited research and understanding, the answer is yes. So conflict resolution is also imperative if you are building a governance model on natural resources. So it need not be always through the intervention of the judiciary or the principles of law that are always there. For example, water. Friends, nationally and internationally, water is going to be an issue of conflict sometimes. You have water interstate conflicts, but we have international conflict also. So let's not look at international conflict right now. Of course, between India and Pakistan, we may have an international conflict on the Indus Water Treaty, but that's also natural resource. Water is an integral part of the natural resource governance system. And two states, we probably don't agree on how much of water sharing should take place and what is the water quality between upper riparian and the lower riparian. So are conflicts and litigations in natural resource management becoming a challenge for the governance system in India? And should you have a model addressing, trying to resolve the grievances arising from equitable distribution of those natural? Because remember, friends, every Indian citizen, we the people, all of us are owners of these natural resources. It's not owned by the government. Government is supposed to be the manager, the trustee of these natural resources for the final beneficiary of the citizens. And hence, friends, we need doctrines, we need principles, we need governance systems about how these natural resources can effectively make India a developed economy by 2047. Can you have the same model that we have had so far? Because, friends, I would put 3 stages in the natural resource governance system in India. First stage, I would call it pre-1991 stage. Yes, that is the first stage in which we developed a kind of a model on natural resource governance, where we thought about some 5-year plans, etc., etc. Then we came up with an era of liberalization, privatization, and globalization post 1991. And right now, friends, as we speak, in the background of climate change, our duty and obligation in international law, as someone who is seeking a permanent seat in the Security Council, someone that is aspiring to become a developed economy, I think the third generation of reforms in natural resource governance has to be brought about. And hence, friends, I think we need to reanalyze, reassess, reimagine the natural resource governance model on different resources, be it forest, be it water, be it fossil fuels, be it the renewable sector. And I think that is the purpose behind what this workshop would attempt to lay down. Of course, we can look at comparative models, international law, but I think looking at sustainable use of natural resources should be the progress forward. The last point that I want to draw before I go to a small segment is about what kind of theory do we look at natural resource governance? What is a theoretical underpinning for governance of natural resources? What is the central argument based on what this governance model should be brought about? Friends, interestingly, there are various theories that are there, but the one that we propose is the theory of restorative justice. And hence, theoretically, on the justice model and how natural resources have to be exploited, what is the duty first doctrine, how do we attempt to restore and bring about the restorative justice mechanism, is something that we all have to debate, analyze. Because it's not easy to, though this theory of restorative justice is fine, but it's not easy to actually put the brass tacks of the same in a given law. So, this is the final point that I would like to draw at this point for the workshop. Today, when we talk about the 3 levels, pre-1991, post-1991, and right now, as we speak in the third generation of natural resource governance, let's not forget this point. We expect governance from the legislature, we expect implementation from the executive, and we expect interpretation from the judiciary. However, very often than not, as it happens in India, many of the natural resource governance is done by the judiciary. The judiciary tries to define what the model of governance is. The judiciary, instead of looking at conflict resolution, lays down the doctrine of managing these resources. As we see in the case of forest, what happens with India's forest is what the judiciary decides. Now, while the judiciary is doing a fantastic job, and it is probably rendering the kind of model of justice in managing these resources, let's not forget this fact, friends, that the judiciary is not supposed to do natural resource governance. So while the judiciary can resolve conflicts, it is not the judiciary's business to manage natural resources or even lay down the governance model of natural resources. So as lawyers, as law students, as students of public policy, as those who may be part of the government, please understand that the judiciary in India is already overburdened with natural resource governance. It's overburdened. And sometimes when you are overburdened, you are bound to make mistakes in the application of law, principles, and doctrines. And slowly we see that trend coming into place. Either the judiciary is over-interfering because of over-activism, or the judiciary is trying to control the entire process of how this natural resources is to be governed. Maybe the justification is because the executive and legislature have failed. But is the judiciary really the institution to manage natural resources in India? I think the answer has to be no, because I think there are other organs of the government that have to actually lead that kind of a background. So I thought some of these points would be very relevant for us to consider before other speakers come into discussing various aspects of natural resource governance. So with this, let me hand it back to Jay, and we'll continue with the speakers as they put forward. Jay, it's over to you.
Thank you so much, sir, for laying down the background of the workshop, especially with regards to governance and how natural resources must be governed and how judiciary has been playing a major role and what the future holds. With this, I take immense privilege to now welcome Professor Dr. Kirk W. Hunker, who is a professor of law and vice president for sustainability, Faculty of Law, University of Cologne, Germany. Sir, thank you for being with us and taking time out of your busy schedule. Over to you, sir, for your insights.
Okay, thank you very much, Jay. Can you hear me okay?
Yes.
Okay, I'm in a borrowed office, so I want to make sure the acoustics are satisfactory. I was only able to hear my colleague, Professor Bhatt, for the past 5 minutes, so I think I've cut the tone a bit. If we look at the workshop in its relationship to our proposed book, the book features as topics, much of which Professor Bhatt has now outlined for us and what the challenges are regarding those topics. If you then look at part B of the book, it is the perspective on those topics from other legal cultures. And this is where my work enters the picture. And I'm excited about this for the following reason. If you look at the history of comparative law, you would see that beginning with the Paris exhibition in 1898, it has largely been conducted as a European, North American enterprise, and very often an enterprise interested in private commercial law. But there's much to be gained both from public law and from law that is not commercial in comparative law. And so the first thing that I'm happy about for our project is that we have comparative conservation law. But the second thing about which I'm even more excited is we have shifted the point of reference. Rather than the point of reference being Europe and how does a state of Africa or Asia or South America compare to Europe, we have shifted the point of reference to India. And we're asking the question in the comparative section, how might these other states compare to India? This opens up a tremendous number of questions that are typically not asked in the method and in the process known as comparative law, because there are written into it a number of assumptions that are very Western oriented and very Eurocentric, or let's add the United States to them. So this is the part that I'm most excited about. When I teach comparative law, and I was just teaching it a moment ago before I came to the room here for our discussion, I use a set of tools from the medieval accessus ad actores, and I force the students to first ask the question, why bother to compare? Why are we comparing? And then you can ask questions about what we compare, where we compare, when we compare, and develop a method of comparison. But the question of why compare, I think, is the most insightful for our work, because it's asking, why would these other states, and for those of you who have not seen the outline for our proposed book, the other states include Uganda and South Africa from the African continent, Australia, the United States, Germany from the European continent, and then Peru from the South American continent. So why compare is a different question for different states, different lawyers in different legal cultures. If I'm in Peru, and I believe Professor Itaregui, if she is not with us already, is joining us at some point today, Peru, like India, is a biodiversity hotspot. Conservation, in comparing Peru to India, is conservation among world biodiversity hotspots and the conservation practices that happen, as Professor Bhatt has pointed out, either through legislative and administrative and executive bodies, or when not doing so, through the judiciary, as he has emphasized. But the object of the conservation is a different cultural object. If you look at US conservation law or German conservation law, you'll find far less biodiversity and a very different approach, therefore, to what is being done in conservation. If you look at Australia and the United States, you find states that have wide open areas for conservation, and one of the legal solutions can simply be preserve and reserve the physical area, because there is a large physical area to preserve. I'm originally from the United States, and there are entire states in Western United States. Wyoming and Montana together are as big as Germany, and they are 95% national park, managed by the federal government. That's a fully different comparative position from which to look upon India, if that is where the author, the writer, is working from. So I'm very interested and excited about the idea that we can shift comparative law outside of a focus on commercial interests and shift it to environmental and conservation law. But I'm especially excited about the idea that we can shift the focus to being India as the norm, for the reason we've said of biodiversity, but also because it's the largest democracy in the world, and look at these traditional areas like Europe and the United States as being the places from which to compare rather than the places to which to compare. I think that's going to generate some really important forward-looking discussion about how international conservation and about how comparative conservation needs to be accomplished in the way that Professor Bhatt has outlined. So I'm going to stop with that, because my piece at our beginning here is to throw in the element of comparison, and then we all will be joining in later with substantive ideas of what one could compare them. Thank you very much.
Thank you, Professor Anka. Just to add, let's take this idea forward. Should there be a rule of law or rule by law? in natural resource governance? Let's see what our response is from the audience. I have two propositions before you. Rule of law. Is it important for natural resource governance? You can say yes, no. Come on, friends. Please participate. Do we know what rule of law would mean for natural resource governance? Is rule of law important for natural resource governance? You know, there are two elements of rule of law. One is accountability, the other is transparency. Let's just take two elements. There are various other elements of rule of law. So in our governance model on natural resource governance, would we want transparency? Transparency of what? Transparency in the way we choose who should explore and exploit the natural resources. Because this is the principle of democracy. Second, whenever we give the chance of exploration and exploitation, be it to a private or a public, how do we hold them accountable in a democratic system? So two principles from rule of law and how these two principles must come in the natural resource governance framework, be it any resource that we are speaking about. I hope all of you are getting the point of reference at this stage. Second, do we expect natural resource governance by rule by law? Rule of law and rule by law. Now, again, I'll refer to the Supreme Court's judgment in Rajiv Suri versus DDA. The reason why I say this, Supreme Court itself, the Supreme Court of India, has laid down the principle. They have said we expect rule of law and we expect rule by law. Right? So again, referring to the Supreme Court, the judicial activism that is driving the kind of management and modern system that we have in our country. So please refer and think about these two doctrines as we go in the discussion of this workshop. It's over today. Thank you, Professor Ranga.
Thank you so much, sir, both of you, for giving the insights and laying down the background of the workshop. Why is it relevant? And of course, the comparative perspective that was put forward by Professor Hanker as well. Now, I would move to the last part of the first session, wherein I would be discussing the constitutional dimension of natural resource governance in India and how does natural resource governance in India look. While Sairam has already laid down the background of the third generation of natural resource governance model in India and the world and why it's critical and how the governance system in India is undergoing a change. He also mentioned about the conflicts and the litigation in natural resource governance, and thus conflict resolution will be critical as to how companies, organizations, and various countries look up to the conflict resolution and how much will the judiciary intervene and how much has it intervened. Now, let's analyze all of these from a constitutional point of view and giving a background for anyone who is here who is not from a law background. So I'll just lay down a slight context and then move forward with the case laws that have already been there and how the judiciary has in some way shaped natural resource governance, at least in India, in the air, water, and the land aspect. So as we all know that governance of critical resources in India lies at the intersection of constitutional mandates, and there are statutory framework and judicial interpretations to the same as well. Now, generally, natural resources such as water, forest, mineral, and biodiversity are those that are available and which are being managed significantly, and they impact the environment, economy, and human rights in a plethora of ways. And their strategic importance is quite vulnerable to depletion, and the role of intragenerational equity make them central to the debates on development and sustainability. And therefore, the Indian Constitution, through originally silent on environment protection, has now evolved through amendments and judicial creativity to enshrine the principles of ecological balance and sustainable use. Now, the constitutional framework places natural resources under a federal distribution of powers, with forests and wildlife falling under the concurrent list post the 42nd Amendment, while water and land primarily are still retained within the state jurisdiction. Now, this federal division often creates institutional complexities in resource governance. the thing that Saram sir was mentioning about the litigation and how it is critical to govern all of these resources. However, the Constitution also embeds the environmental and distributive justice aspect principles within the directive principles of state policy, concerning Article 39B and 48A and fundamental duties under Article 51AG. Now, apart from the constitutional framework that is laid down by the Constitution, the judiciary has also played a very critical role in this regard. Now, please allow me to share my screen. I will just share my screen and take this forward. Kindly confirm once my screen is visible to everyone.
Yeah.
Thank you. Now, the judiciary has shaped the governance and safeguarding of natural resources through expansion of constitutional principles and interpretation of environmental rights in India especially. Now, the courts have consistently emphasized that natural resources are not mere commodities for commercial exploitation, but also an essential aspect to life, dignity, and sustainable development. Now, the foundational judicial contribution in this area has been the articulation and application of the much appreciated and well-known doctrine, that is the public trust doctrine, most notably that came out in the MC Mehta and Kamalnath case in 1997, wherein the Supreme Court declared that the state holds natural resources as a trustee of the people and cannot alienate them arbitrarily and for private gains. Now, this doctrine has been the bedrock of judicial reasoning in cases involving forest, rivers, and mineral resources in our country. Now, the court has reiterated time and again that the government is not the owner of natural resources, but merely a guardian with a fiduciary responsibility to preserve and manage these resources for the benefit and intragenerational equity. Now, to understand this doctrine better, let's take the example of the case in MI Builders Private Limited versus Radha Shyam Sahu. The appellant was given the possession of a park. It was a public park. Now, the single open space in the market of Aminabad was in violation of the law so that they could construct an underground shopping complex and underground parking with the pretense of relieving the area from congestion. Now, the Supreme Court applied the same principle and relied on the treaties of environmental law and policy, nature law and society by Plato, and expounded the philosophy of public trusteeship out here that rests upon three connected principles. Firstly, it would be unwise to make certain interest like the air and the sea. The subject of private ownership would come up for the reason that these are crucial for the community as a whole and not just one individual section. Secondly, they have to be available for everyone without any cost, regardless of economic situation, since they are largely a product of the bounty of nature instead of any personal or private commerce. And finally, instead of redistributing public commodities from wide public uses to narrow private use of benefits, one of the government's main goals is to advance the interest of these entire population. So the court ultimately decided that the underground development broke the public trust principle, and hence the idea was dropped of the open park. Now, in this backdrop, let us see how the judiciary through various interventions has shaped certain resource governance. Now, first in the mineral sector. Now, in India, the Supreme Court's decision in Reliance Industries Limited versus Reliance Natural Resources Limited stands out for the firm reaffirmation of the state's regulatory authority over the natural gas sector. Why is this important? Because through this judgment, the court explicitly endorsed the prevailing regulatory regime governing the scarce and essential resource. Now, presently, the gas utilization policy that was devised by a group of ministers governs the allocation of natural gas. Now, under this policy, the bulk consumers submit requests for gas supplies, and the allocation are made based on predetermined priorities. Now, this structure was designed to manage the imbalance between overwhelming demand and limited supply, as India's natural gas reserves are confined to a few extraction sites across the country. Now, in this case itself, it has been clarified that natural resources situated within the Indian territory are vested in the Union, but this vesting does not confer unfettered ownership in the traditional legal sense. Rather than an absolute power, the Constitution imposes a fiduciary duty upon the state to manage these resources in a more responsible manner. Now, while the conceptual connection between these had been acknowledged in earlier jurisprudence earlier, this was the first time and in the first case that they were directly linked to the state's custodianship over natural resources. Now, coming to the next aspect, wherein the state is under a constitutional duty to ensure both equitable access to and fair distribution of natural resources. Now, the goal is to avoid a scenario where a privileged few benefit disproportionately while the broader public interest is undermined in one way or the other. So the obligation gains even greater importance and significance today as a part of this workshop when private entities have been permitted to participate in the extraction and commercialization of natural resources. Now, while such involvement may promote efficiency and investment, it raises complex questions regarding the regulatory responsibilities of the state in a liberalized economic environment that today we involve in. Now, coming to the last or the third aspect of the presentation, which is land and forest, wherein the respective states act as a guardian and custodians. In the year 2023, the Supreme Court came out with yet another landmark judgment, which is mentioned in the slide also, the Anil Agarwal Foundation versus State of Orissa. Now, the facts of this case is quite simple. It is that the foundation requested for 15,000 acres of land from the government of Orissa to build a university. Now, the government of Orissa granted 6,000 acres of land to the foundation at the Puri-Konark coastal belt. It's an eastern state in the state of Orissa. Now, the matter was taken up by the Orissa High Court, which quashed the land acquisition proceedings and directed the possession of the acquired lands shall be restored to the respective owners. And then the foundation once again went to appeal before the Supreme Court of India. Now, the court also pressed on the fact that these lands were held in public trust. So the Supreme Court also took note of the same. And as such, that the state had no authority to alienate them in a manner that contravenes the law and benefits one single private entity. And in a very rare yet necessary act of restitution, the court directed the state, and it sided with the High Court's judgment, to return the lands with the original owners and revoke any leasehold interest conferred upon the beneficiary company, including the government lands. Now, even more important in this case was the court relied on Article 14 of the Indian Constitution in the land acquisition matter, which is quite rare. So this episode actually illustrates how, when the state failed in its constitutional duty to act fairly and in accordance with the law of the judiciary, both the High Court and the Supreme Court facilitated the unlawful deprivation of citizens' property, ignored ecological concerns, and disregarded procedural norms, and safeguarded the interest of 6,000 families living in the disputed area, which also involves forest and rural lands as well. Now, coming to the last aspect, which is the atmospheric trust doctrine that had come up in the Juliana case. Now, this is an emerging and compelling extension of the public trust doctrine that we have been speaking about. Now, when applied scientifically to air and atmosphere as a shared natural resource, it represents a paradigm shift in how we understand the state's responsibility towards atmospheric protection, particularly in the face of global challenges like air pollution and climate change. So traditionally, air as a natural resource has not been managed as a tangible resource in the way of forests, rivers, or mineral resources. However, as the air quality today degrades and impacts of greenhouse gases emissions intensify, there is a growing recognition that the atmosphere must be treated as a finite and vulnerable commons requiring legal protection and public stewardship as well. So at the core of this doctrine, it persists that the atmosphere is a trust asset, a resource that the state holds for the present and future generations. And under this doctrine, the government has a fiduciary duty to protect and prevent substantial harm to the atmosphere, to maintain its quality, and to ensure its equitable use. So this aligns conceptually with the constitutional principles in India, particularly Article 21 that has been expounded variously in numerous cases to extend to right to life and a dignified life, which courts have interpreted to include right to clean air in Article 48A, which directs the state to protect and improve the environment. Now, with this point of view, coming to the last aspect as to what are the key takeaways and what do we take out of this short presentation that we have. One, the judicial evolution of environmental constitutionalism. Now, the Indian Constitution was originally silent, as we saw, and through amendments and judicial interpretations has evolved as a powerful framework for ecological balance and has gone into the duties of the legislature to legislate and also to execute certain decisions of the judiciary itself. Second, the public trust doctrine as a governance principle we have already discussed. Third, the state's fiduciary duty over natural resources. Now, the judiciary has firmly held natural resources such as minerals and gas, which vests upon the union not as a property but as a constitutional mandate of custodianship. And we saw in the Reliance case, the court reiterated the state's duty to ensure an equitable distribution and prevent an elite capture over these resources. Fourth, the judicial redress for states' failure in land governance. The last case law that we saw in the Anil Agarwal Foundation case, how the court intervened when the state action undermined the public interest and environmental norm. So by ordering the restoration of lands to the dispossessed rural families, the judiciary enforced both ecological justice and procedural fairness as well. And lastly, coming up with the new doctrines as time is passing, like the atmospheric trust doctrine, which is the extension of the public trust doctrine, and a new legal concept that treats air and atmosphere as a commons requiring the state's active stewardship in this particular area. With this, I conclude my presentation, and if there are any comments from the experts out here.
Okay. Let me just add to what Jay has presented, but raising a few issues for the participants to, engage themselves by the use of their comments in the chat box. Participants, are you willing to interact with the speakers using the chat box? The answer is yes. Okay, great. So let me just ask all of you, how should the government allocate natural resources? What is the policy of allocation of natural resources in India? How do we do it? Suppose, you give it to the public sector. How do you give it? Maybe you nominate. Okay. So coal, for example, Coal India Limited is the dominant player extracting coal in India. It's a public sector organization. So by nomination, they get the right to extract coal blocks. I'm sure Raghav will deal with this, but I'm sure while you look at allocation, there is a doctrine of discovery. Have you heard about this doctrine of discovery, ladies and gentlemen? No. Okay, Raghav, you have something that you should address. So Raghav will definitely talk about doctrine of discovery. See, simple. He will definitely put it in the oil and natural gas sector. But someone can discover natural resources, right? Something that was not already there, and that's what the Reliance case is all about in the Godavari Basin. And sometimes we say the one who discovers also gets the right to capture. We call the doctrine of discovery and the rule of capture. Okay, so it's possible, right? So that is one way of allocation. But what is the other way of allocation of natural resources in India? Come on, anyone?
Through auctions.
Santosh is saying through auctions. Okay. Santosh, do you know about Colgate case? Colgate? Not
Yes, sir. Yes, sir. Previously, first come first service में वो that was the time. So that time it happened like this.
Colgate में वैसा नहीं था, but वो 2G case में. सही है, you're right. But how many of you have seen the CAG report? Now, while Jay was talking about constitution, and I spoke about rule of law and accountability, how many of you know about the CAG report in the Colgate case? Friends, coal is one of those vital natural resources in this country that is propelling the energy sector by use of coal in thermal power stations and actually supplying electricity to our homes. So please note, coal and thermal power constitutes nearly 40% of our electricity requirements. Am I right or wrong? I'm right. But how was coal blocks being allocated? Do you know that after the Supreme Court intervened in the Colgate case and after the CAG report came in, the Supreme Court said that, look, these are the vital natural resources of this country. The government, supposed to be the trustee, should go by auction because, like Santosh said, auction brings in transparency, it brings in competitive bidding. But how was it being done in India, Santosh? How was it being done in India before the coal gate scam? No one is answering. No one is bothered about the country's vital wealth of the nation and how it was governed. You know why? Because we didn't ask accountability from the executive, from the legislature. And then finally, CAG report had to, throw away a scam in 2010. How was it being allocated? Do you know how was it being allocated? Very interesting, friends. So I believe, friends, the Colgate case of the Supreme Court is an important case because it talks about accountability and transparency in allocation to the private sector and to the public sector. And they did suggest that auctioning should be one method. And please note, when the coal blocks, 11 coal blocks were auctioned after the Supreme Court judgment, do you know how much of revenue the government earned with the auctioning of 11 coal blocks? 80,000 crores. You can't probably figure out how many zeros are there in that 80,000 crores. But how was it being done all throughout the 1990s and 2000? Ladies and gentlemen, it was done through a committee minutes of the meeting. Just 2-page minutes of the meeting were drawn, applicants were scrutinized, and they were given the vital wealth of the nation. And interestingly, friends, the biggest point of something that you must think about, and that's why I said we are at the verge of the third generation of reforms that is required in natural resource governance, is because you may allocate the coal blocks through auction. Santosh ji, please listen to me. You may still follow the competitive bidding process and 80,000 crores comes to the government. But Santosh ji, do we have an accounting system? How much of coal is being extracted from these blocks? Where does this coal go? So Santosh ji and all participants, please, how many of you have seen the CAG, the Comptroller and Auditor General of India's report on natural resource accounting? Have you seen this? At least say yes or no. What is the purpose of this workshop? The purpose of the workshop is to equip you, to encourage you, to motivate you, and also to instigate you. Because we have to reimagine this model. Please look at the CAG Natural Resources Accounting report. Because, friends, accounting is important. Who is extracting how much? At what value? What is their profit? Is it import or export? For example, Santosh ji, who has the first right on the natural resources of coal? Indians or the one to whom it is exported? Let's assume China.
Indians. Indians.
So the answer is straightforward. But how much of coal has gone to China? And that itself, Santosh ji, was the Shah Committee report of the mines in Goa. Because the iron ore mines in Goa was completely exported to China. So, friends, our history in the past on accountability and transparency in the natural resource governance has not been great. We need to improve on it. We need to work on it. Legislatively, executively, and maybe judicially. Now, why I believe natural resource accounting is important? Because Santosh has kept his video on and he's probably interested in this topic. I'm addressing it directly to him. I hope every participant may be, now tempted to switch their video and be interested in this debate. Friends, what is the value of a tree? Accounting. How much is the value of a tree in India? Anyone, quickly answer me. We need to value the natural resource, right? What is the economic value of, say, 1 kg of coal, 1 kg of iron ore? Do I have an accounting and a valuation system? You're getting what the point I'm trying you to think about. What is the value of a tree? Because Gehlot, because he has written on forestry. Friends, the value of the tree in India is nearly 74,000 per year. We have done valuation, and that valuation will help us do accounting. So if a tree is 100 years old, and if this tree is going to be utilized as a resource, then the value and what the resource valuation is nearly 74 lakhs. And that is the way we have come about with a system of restorative justice. So if I cut 100 trees of 100 years old, then I exactly know how much I must pay for restoring and replacing those trees. So accounting and valuation of natural resources is a very important component of governance. Let me repeat, I wouldn't want to emphasize. Accounting and valuation of natural resources is an important element of natural resource governance. While transparency, accountability, all of that is. Now, I just want to conclude at one specific instance. Listen to me, everyone, please. Attention required. Online session, not easy, but let me bring your attention. When the Supreme Court of India said that coal blocks must be auctioned because that will ensure competitive bidding, transparency, and accountability, the existing systems were not correct. The government of India auctioned coal blocks. As I told you, 11 coal blocks were auctioned. The government got a bidding amount of 80,000 crores, which had to be given in a staged manner. Now, please note, in 2014, all young lawyers and scholars, please listen to me. There was a presidential reference to the Supreme Court, which asked the Supreme Court, you have said that there should be auction, but should auction be the rule or should it be the preferred mode? Now, let me tell you why this is important. Santosh ji, look, if I take part in an auction for a coal block, I have to pay 10,000 crores to the government, correct? Competitive, right? Now I pay 10,000 crores as a royalty or a fee to the government. Then I extract coal. So it is A plus B cost. Then I sell this coal to the thermal power station. And thermal power station has a C cost, correct? And then this energy or electricity is going to the consumer. So did auctioning of coal increase electricity tariffs in India?
It's a very good question, sir. Very good question, sir. Actually, everybody has to think about it. So auction.
No, I want answers.
So even though
increase the electricity costs in India?
Yes, sir. Of course.
Because
sir.
Remember, I have to take part. It is a competitive bidding process. One who puts the highest bid gets the coal block. So there is a cost involved in auctioning. Then there is a cost involved in extraction. There is a cost on which I have to sell it to the thermal power station. The thermal power station has an operational cost. Then I sell this electricity to the final consumer. Did it increase the cost of electricity in India? This was asked to the Supreme Court of India in a presidential reference. And the Supreme Court said, yes, it does. And hence, from a rule, they said it is the preferred mode. It is preferred. It's not a rule that it should be auctioned always, but it is the preferred mode of ensuring transparency and accountability. So I think we have a great jurisprudence that is already laid down in the history of how natural resource governance has taken place in India. We have enough examples to set the house in order. And I think if we don't learn from these lessons and we don't lay the roadmap for a Viksit Bharat of 2047, I think we would do a lot of disservice to the legal fraternity. So lessons learned, takeaways there, examples are sufficient enough, and hence the roadmap to proper natural resource governance is something that we all have a responsibility to adhere. Yeah, it's if Ankar has anything to add, we can welcome that, or we should.
Thank you, Professor Butt.
Close.
The only thing, the only point I think I want to add there, and you alluded to it earlier, is too often in such situations we come up with an idea called best practices, and best practices is best for whom needs to be asked. And it's not asked, it's in fact treated instead as though it's some sort of abstract absolute. That one legal practice in one culture would be the best one for another legal culture in a different application, even for a different resource to use. And that's the only thing I want to add at this point, is that I encourage staying away from the concept of best practices. The specific question must be asked for this community, for this culture, for this resource, what should be the practice? Not that there is some sort of general best practice.
Absolutely. I think that's something that's very, very relevant and important is that, while you talk about natural resource governance as a uniform challenge, but that does not mean you have uniformity in allocation production. So I think every natural resource has its unique, characteristic, its use challenge, its allocation responsibilities, and hence we have to develop those kinds of models, keeping those challenges in place. So with this, I think we should close the first session, which is just setting the tone on the likely challenges that are there in the natural governance system. But please note, I would also add the word called the management challenges as well when it comes to natural resources. And we should now get into the specific, resource and try and evaluate the governance and the management challenges that exist. So with this, and right at 4 p.m., sticking to the allocation of the schedule, we close this session and we thank Professor Ankar and Jay for their presentation and move to session number 2. Jay, it's over to you.
Thank you, sir. Thank you, Professor Hunker, for your insights, and Professor Sairam for raising some very critical insights and questions that will be addressed in the upcoming sessions that are remaining. With this, I invite Advocate Raghav Parthasarathy, who is a practicing advocate and a research scholar at GNLU, Gujarat. Over to you, Raghav.
Thank you, Jay. Thanks for organizing. Thank you, Sairam, sir, for organizing.
Raghav,
yes, sir, please. Please.
Raghav, I'm just looking. Every participant is free to use the chat box for raising questions. The speakers may not have sufficient time to orally address the same, but I, as an organizer, make a humble request to all the speakers that please respond to questions in the chat box, address the questions so that the takeaways and the learnings are there as well. So the chat box is very free for interaction. So Raghav, please.
Thank you, sir. Thank you so much for this workshop. And I thank Jay and Sairam sir for the workshop and for the opportunity. Now, in today's session, I would like to deal with the topic on the regulatory framework for the upstream sector in the oil and gas sector. Now, the interesting part of this whole discussion that I would like to take you all through is the sector-specific discussion. Now, since I'm researching, I'm trying to learn more about the oil and gas sector, and it also covers different forms of hydrocarbons. I would like to discuss about the regulatory governance framework in this particular sector. Now, if we have to look at the sector as a whole, the oil, gas, and the hydrocarbon sector in general is itself classified basically into 3 streams. First is the upstream sector, second is the midstream sector, and third is the downstream sector. Whereas for the midstream and the downstream sector, we have a specific legislative framework called the Petroleum and Natural Gas Regulatory Board Act of 2006. For the upstream governance, we don't have a specific legislative framework. Now, you may be wondering, how is the upstream framework then functioning? Now, before I get into that, I would like to just tell you in brief what exactly do we mean, or what does upstream sector specifically deal with. Now, when we are talking about the oil and gas sector in general, it can be divided into different aspects, starting from the activity of exploring till it reaches the end customer, right? Like we all use oil and gas on a day-to-day basis, right? It has gone through a specific process. Now, what is this process? It has firstly gone through the upstream process, then it has come through the midstream process, and during the downstream process, it reaches us, right? We are the end customers. Now, you may be asking as to what do you mean by the term upstream sector? To just simply understand the term upstream basically means the exploration and production activities, right? Now, the term exploration basically means that you undertake a survey of a possible area where you anticipate that there is some oil or there is some hydrocarbon resources beneath the surface, right? So the exploration part of it is undertaking a survey, conducting a study and assessment of whether there is a resource that is available for commercial exploitation, right? Now, this activity is purely under the upstream sector. And in addition to this, once the exploration is successful, by the term successful, I mean that if the contractor or if a particular party is able to identify specific resources for the purpose of commercial utilization. Now, please understand that just because I have probably discovered a little bit of resource, it does not make it available for utilization, right? For someone to invest in it, it has to be commercially viable. It has to be commercially feasible so that he can make profits out of the resources, right? Now, as we all know, India is not very rich in terms of oil and gas as of now. Again, it goes with a caveat that it is a continuous process. The exploration activity is, again, it's not complete, in the sense we have both offshore areas, onshore areas through which there can be a lot of scope for discovery, right? Now, as on today, India is a resource scarce, in the sense oil and gas resource. It's a scarce resource in India, and mostly 80 to 85% of it is being imported as on today. Whereas a very limited amount of, say, 10 to 12% is being produced within the country, in the sense we extract the resources from beneath our lands, right? Now, this is the in general idea of the upstream sector, right? Once the oil and natural gas gets explored, gets extracted, it moves to the production phase, right? Now, once it is taken out from the earth's beneath the surface of the earth, it requires to be transported from a particular place to a particular place B, right? Now, this particular process of transportation from place A to place B is classified under the midstream sector, right? Now, not just the transportation part of it, but there is also another part of it which is called the storage. Now, what do we mean by the term storage? Please understand that unlike the power, unlike electricity, right? This resource is a finite resource, and we need to store it, in the sense we need to use it for the purpose of sustainability for the welfare of the future as well. When this is the scenario, government has introduced a lot of policies on this aspect, especially when it comes to strategic petroleum reserves. Now, please understand that if, say, for example, God forbid something like that happens because of a war breakout or because of some uncertainty in the global market, right? The oil supplies get stopped all of a sudden. Where do we go? What is the alternate that we have as on today, right? We still have to think about all this. Therefore, the government, way back in the year 2004 itself, that was during the NDA one, in the first when the first government was there. It was during that point in time that the strategic petroleum reserves were first established, and it was conceived as a possible alternative. Again, that is not sufficient for the reasons that we only have around 4 or 5 places which stores the huge amount of petroleum and oil resources. Now, this storage is specifically within the ambit of the midstream sector, right? Now, what does the downstream sector entail? Please note, the downstream sector basically entails that there is a process of refining. Now, this refinement process basically leads to byproducts of oil, petroleum, right? Now, if we have to take the example of plastic, we have to take the example of Vaseline, or say, for example, any other products derived out of the petroleum and oil products, right? All these are specifically within the downstream sector. Now, please note, for the midstream and the downstream, we have a regulatory framework called the PNGRB Act that is under the 2006 legislation. Whereas for the upstream sector, we have a specific authority that is not a statutory body. It is more of an administrative body. Again, it has certain regulatory powers, but not in the sense of what the PNGRB conceives, right? So the Directorate General of Hydrocarbon is the regulatory authority for the upstream governance framework. Now, you may ask, why is it not a regulatory framework? In the sense, why is it not a statutory authority and instead only an administrative one? Now, please note that in the year 1991, this particular authority was established under the direct control of the Ministry of Petroleum and Natural Gas. Now, once this particular authority was conceived, it was conceived on the basis of a foreign model. If I have to take the specific case, it was based on the Norwegian Petroleum Directorate, right? Now, Norway has a specific regulatory framework, also a statute called the Petroleum Directorate, Norwegian Petroleum Directorate. And this particular authority looks after the upstream exploration and production activities within the country. Now, this was the model which was very similar, and we have adopted a similar model in our country, and we have given the name as Directorate General of Hydrocarbons. Now, you may ask, what is the need for having a specific regulatory authority for each of these things? Please note, in the upstream sector, there are multiple issues and multiple challenges that the contractors are facing on a day-to-day basis. Now, what are these issues? Recently, in one of the cases that was decided by the Delhi High Court, a very interesting issue came up for the adjudication. Now, the issue was there is a contractor who is extracting natural gas from the basin, that is from the block that is allocated to him. Now, once that block was allocated, it so happened that there was an adjacent neighboring block which was also allocated to another authority. Now, in this particular case, it was the ONGC, Oil and Natural Gas Corporation. Now, ONGC was carrying on its own exploration and production activities. Besides it, the Reliance was undertaking its own exploration and production activities under their respective licenses and under their respective leases. Now, it so happened sometime in 2005 and 2006, ONGC realizes that the gas which was there in their block has migrated from their block to the Reliance block, right? Now, because of this, what has happened is Reliance, of course, under the respective licenses, under the respective lease, they are going on extracting whatever is getting beneath the surface of their land. Now, please note that it was a duty on part of the Reliance, it was a duty on part of the ONGC to have informed the concerned authorities about the possibility of there being a gas migration. Now, this led to an arbitral dispute for which the High Courts also intervened and arbitration was constituted, and the arbitral tribunal held it in favor of the company, that is the Reliance Corporation. The arbitral tribunal held that it says the Reliance was fully entitled to produce all the hydrocarbons that was granted under the production license, which was issued by the central government. Now, this particular contract area where the Reliance was extracting, right? The arbitral tribunal says it had full powers to extract whatever was there beneath the surface, right? But a very interesting issue or very interesting aspect was not answered, and it remained unanswered. Even today, it remains unanswered, right? Now, please understand, in India, we don't have a very strict concept on the doctrine of capture. Now, has anyone dealt with the concept of doctrine of capture? If so, you're free to please comment on this. Please put a comment about what's your understanding of the doctrine of capture, and we would like to take your views on that. Now, in addition to this, the other interesting aspect that requires to be looked at is the doctrine of public trust. Now, please note, ONGC is a public company, which means it is a government establishment, right? Now, this government establishment having acquired necessary licenses, even though operating in its own private capacity, but whatever extraction of resources takes place, please note that it is for the welfare of the entire country. It is not just for a particular company or for any particular entity. Now, therefore, the essential issue that requires to be addressed in this particular case was whether the doctrine of capture was applicable or whether there was doctrine of public trust that requires to be applied in the present case. Interestingly, the matter was dealt with by the arbitral tribunal, which was not answered. It went before the single judge bench. Again, it did not hold the doctrine of capture, nor it discussed about the public trust doctrine. It was also recently, I think sometime in the month of February 2025, the division bench of the Delhi High Court also gave a decision in this particular regard, in this particular matter, wherein it was an appeal by the Union of India challenging the order of the learned single judge by way of a writ appeal. The order of the learned single judge was challenged, and the division bench also came to a conclusion that, of course, whatever was being extracted by Reliance was held to be illegal or probably beyond the scope of their production sharing contract. But the law was not laid down, neither the issue of gas migration addressed in any of these aspects. I hope at least the Supreme Court takes up this particular issue and answers it. Now, please understand, gas being a very scarce resource, these critical aspects, these critical principles become a very important point, or it lays down a very important jurisprudential point of view for future contractual frameworks, right? Now, also, the other issues that are prevailing in the upstream hydrocarbon regulatory sector is that everything is governed under the production sharing and the revenue sharing mechanism. Now, please note that the government at the time of allocating a particular block that could be either onshore or offshore, right, issues a production sharing contract or a revenue sharing contract. Now, the revenue sharing contracts and models are available online. Please feel free to go through these models for better understanding of how the oil and gas sector in India works. Now, if you go through these contractual frameworks, you will understand that most of the disclosures, right, are all coming through the contracts itself. Now, in addition to the disclosures, it is also important to look at the environmental obligations. Now, since we are discussing about the resource allocation, resource management, we need to understand that there is a critical environmental component that requires to be taken up not just by the contractor who is involved in exploration and production, but also by the government of India, which has to lay down certain obligations on the contractor to maintain the quality of the area that it is probably operating in, right? Now, if we have to take the example of the onshore areas, we have legislations like the Environment Protection Act, Water Act, Air Act, so on and so forth. But if we go to the offshore areas, can we use the same legislations? Even though you may say yes, but are these authorities, say for example, the concerned pollution control boards, are these authorities adequately empowered, adequately provided with sufficient resources to get into those areas and probably fine or penalize the offenders? I would say no. Therefore, what has happened is most of the environmental obligations have been provided under the contractual framework itself. Now, because of the contractual obligation, most of it does not get most of it does not become public. In the sense, it remains outside the purview of public discussion. It remains outside the purview of the public knowledge in majority of the times, right? Therefore, a regulatory framework for my argument, specific argument is that a regulatory framework for the upstream oil and gas sector, more so the hydrocarbon sector, is the need of the hour. Because the ultimate objective that we achieve through this is, firstly, there is decentralization of the power. In the sense, since the DGH as on today is operating as a wing of the government, it gets decentralized by way of a statutory framework. And because of this decentralization, there is at least a scope for certainty there is transparency and accountability that can be expected out of this particular authority. Now, in addition to this, if we have to say, what about the investor confidence? Now, please note, any investor who is putting in his money would want to have some kind of certainty, would want to have certain kind of stability in the sector. Now, because of the change in rules, because of the change in government, the investors are always apprehensive about how the sector will continue or how the sector will thrive, right? Now, because of this, there requires a specific uniform mechanism to address all these issues, right? Now, my argument specifically is that a specific legislation is the need of the hour, not just in terms of maintaining the federalism or probably decentralization of powers, but it is also for effective utilization of resources to ensure that we get adequate investments in the sector and probably achieve whatever our goal probably is in the next 10 to 15 years of becoming a Vikasit Bharat concept, right? So thank you so much. If there are any questions, please feel free to raise. I would answer it in the chat box. Thank you. Thank you, Jay. Thank you, sir.
Thank you, Raghav, for those insights in dealing with upstream and downstream and explaining those concepts so properly to everyone. And of course, why we need a security in the crude oil sector, what happens and energy security. With this, I would like to invite the second speaker in session number 2, Dr. Vidya Ann Jacob, Associate Professor, School of Law, Christ Deemed University. I hope, yes, ma'am, you're here. So over to you, ma'am.
Thank you so much. And thank you, Sairam sir, for this opportunity. I will just share my slide. I hope the screen is visible.
It is.
Yeah.
It's
Okay. Yeah. Thank you so much. And it's an honor to share the panel with esteemed friends, as well as, I mean, it's lovely to see you, Raghav, and all the others who are there. So today's work that I would be kind of looking through, just a second. Yeah. So I'll just give a small introduction as to what critical mineral resources is, a jurisprudential understanding of common resources, and just to correlate it with natural resources and critical resources. And looking at it from justice perspective, I do understand that Sairam sir has looked at restorative justice as one of the angles, but I will also be looking at a couple of more theories to just understand how justice and equity can be better put forward. Then I will also be just looking at the 2024 Australian bill, which talks about critical mineral resource and how they're planning to kind of move towards the goal on the climate net zero impact. And then we'll be just looking at the laws governing the governance and management with respect to critical resource management in India and a couple of key pointers. So just to start off, we all have been reading about it a lot, that India is being world's third largest consumer of energy. And we're also having a very ambitious clean energy goal. And when you say clean energy goal, that means that you'd really require more and more of mineral resources. And a lot of our mineral resources, especially the critical mineral resource, comes from imports rather than from the country itself. So one of the steps that India has been taking to secure this critical mineral essentials is to look at its energy transitioning. So in 2025, January 29, the Union Cabinet has approved the National Critical Mineral Mission. And this has been vital for us because this focuses on strengthening the value chain, on increasing domestic production, then with respect to acquiring critical assets abroad, and as well as recycling critical minerals, mobilizing human resource, which is a huge aspect for a country like India. And the last pointer would be with respect to finance. Now, when we talk about critical mineral resource, the first thing that we should have in mind is that as per data, we have very few countries, or about 55% of the mineral resources is been revolving around 15 countries. and internally they're putting in ban and higher cess or taxation policies, which kind of prevents countries from procuring it. Like, for example, our EV vehicles require lithium, and we import quite a bit of that. And when countries which have access to mineral resources are putting a higher tax for export or for importing the goods, it kind of becomes like a challenge for developing countries like ours to meet the demand. Now, if you look at our NDC, the National Determined Contribution, we have stated by 2070, we're going to be net zero. And when you talk about net zero, one of the main elements or core resources that we have to be reliant on is our mineral resources, the critical mineral resources. And we also are aware that India's strategic and defense sectors also are kind of reliant on the critical mineral resources for manufacturing of defense requirement. So setting that in tone, I'm just going to start off with the aspect of common resources. Now, the reason why I put this across is so that all of us are on the same page with the understanding of the mineral resources and why the management, or why we need like a regulation and what should be done to go forward. So if you look at natural resources per se, it is termed as a common. So everything that you see from your air, your ocean, your public parks, your public wells, all of that is owned by everyone that is there living in that community. In 1968, we had the concept of tragedy of commons, where we had Garrett Hardin, who stated that if an individual is given the right to exploit a resource or a shared resource, and if it's not regulated, we'll end up having depletion, or we'll end up having over exploitation of the resource. So jurisprudentially, jurists thought that the best way to kind of have some sort of a balance or sustainable practice would be, one, if you can regulate it. So for example, we have the environmental law in India, which kind of talks about postal regulation, or with respect to how do you use your resources. Then with respect to privatization, so assigning a private right with the usage and control. So at the same time, you have sustainability and also giving them the exclusive right to govern it. Or it could be a community-based management where the local or indigenous governance is being promoted. So for example, if you look at the Paris Agreement, we do have the concept of climate justice, and in that, we also see that indigenous communities of late have been given a lot of importance with respect to the traditional knowledge to kind of preserve their practices in kind of helping us restore our resources, as well as protecting the forest and so on and so forth. So jurisprudentially speaking, we do have steps taken, which we see in different facets. Now, when I talk about justice in critical resource development, there are three important aspects that I'm keeping in mind, looking at the 2025 mission and the goal that we have in 2070 to go net zero, which is basically integrating your climate, environment, and energy justice. Again, all these three are very different, but at the same time, interrelated aspects. Now, and this is to ensure that the inequity or the injustice that's kind of been widening. So something that we do see is it's always the vulnerable communities which keep getting, the inequity keeps widening, and and that's why that disproportionality is also kind of met with. So if I have to view critical resources through the lens of distributive justice, then we're looking at the energy industry as shared, as well as who would bear the environmental harm. And this is a huge debate that we've had even from an international perspective, saying that why should developing countries bear the brunt when you have the developed countries who've enjoyed and who've exploited the resources, and the developing countries should be given a cut or a slack to ensure that we have been given some sort of a bandwidth to kind of progress into the developmental arena. Then coming to procedural justice facet, it is with respect to where emphasis is given on procedural and all legal aspects. So one of the questions that you can think of is, we have environment impact assessment or statements that is actually being put forward, but how far are we actually following it? Okay, and the reason why we have environment impact assessment is to ensure that there is minimal disruption. At the same time, we are, like Sir was also mentioning in the first opening remarks, about preserving the resources for the future generation. So if you actually look at a small study that I'm currently conducting in Kerala, where we're looking at fishermen communities and climate victims. So we're looking at how their beaches, which is again a common resources, is being taken over off late by the Adani group. And currently they're saying that they're going to develop it and there's going to be a harbor, which is going to be beneficial for the community at large. And of course, if you look at the public trust doctrine, the state is the trustee on behalf of the citizen, and they're doing the best for us. But when you go further and do a field study, something that you realize is all these communities are going to be displaced, and the resources that they have been relying on for generation is not in their hand as per law. The third aspect that we would look into is with respect to recognition justice, which basically looks at various social groups and their rights acknowledged. So for example, we keep talking about the indigenous community and their rights, and how even if under the Forest Act, you have the Forest Rights Act, you give the indigenous communities the right to passage, or with respect to collection of goods, and then ensuring that they are able to, continue with their practices and so on and so forth. But the question is, how far are these communities' rights, or how far are these communities included in decision making? Or even when you talk about critical resource management, when it comes to large projects or with respect to licensing, are these communities actually involved in any way? The next aspect is with respect to cosmopolitan justice, which is basically looking at it from a global citizen's perspective. So for instance, if you take with respect to consequences that our activities have on the borders or beyond our borders, how far are we actually catering to that? And the last point is restorative justice, which Sir has already kind of reiterated, so I'm not just going to go into that. Now, if you look at one of the steps or one of the aspects that the Australian government has looked into when it comes to critical critical mineral resources, they have their 2024 bill, which is called the Future Made in Australia Production Tax Credit and Other Measures Bill 2024, which is kind of very focused towards ensuring promotion of critical resources within the state, which means that they do have incentives and tax they do have like a tax rebate when it comes to critical resources inside Australia and usage of it. And in the process, they're trying to ensure that Australia does not import critical resources, but then try and ensure as much as, just like how we have made in India, they have more of made in Australia goods or made in Australia minerals, which would be kind of helping them achieve their net zero emission as per the Paris, as well as ensuring the economic development of their country. Now, if you look at the bill that has been put out in 2024, one of their main mission is also to strengthen the national economic resilience and create high quality employment opportunities for Australians, which means that the more and more, so Australia does have a huge mining industry, which is out there, and the resources quite huge. So by promoting this and by incentivizing it, they're also kind of showcasing the world that they are self-sufficient and they can actually move into sustainability and self-reliant opportunities. Now, coming to India's critical mineral resources laws management just generally. So the latest is our 2025 mission. Again, when I say mission, it's we don't have a legal teeth into it, but of course it's a policy, a guideline, which we are relying on. So you have a comprehensive plan, which is guaranteed by the government for essential minerals. Second, they're looking at strengthening international partnerships. So India has already established a partnership through the Mineral Security Partnership and a bilateral agreement with countries like Australia, Argentina, Chile, and a joint venture with Kazakhstan. Further, we do know that Kanji Bidesh India Limited, which is started in 2019, It works with respect to procuring lithium and cobalt in foreign countries such as Argentina and Australia. That's been assigned to them. Further, this particular mission focuses on strengthening trade and market access by way of critical mineral partnership, as well as it looks into free trade agreements. Further, one more aspect is that they do provide some sort of incentives and investment policies for research and development when it comes to critical mineral processing and extraction technology. Now, the problem is when it comes to capacity building and when it comes to transitioning, is India, as well as the industries, up for it or not is a huge question. I mean, we do have these long-standing promises and long-standing missions that we do put forward, but how far can we reach it is a huge question. So that's the reason why I would say this is because when the NAPAC or the National Action Plan on Climate Change also came in 2008, I mean, it's already 2025. The missions had such long-standing promises, but none of it has been met yet. And we still don't have anything on a climate change framework or an interpretation that is given, except for the Supreme Court judgment, which came in very recently. And of course, that's a good start for us. Now, coming to the Mines and Minerals Act of 1957, which is the oldest act, but we do see that they have brought out a lot of interesting, they have brought in a lot of amendments of late. So one of the reasons why this particular act was brought in is to regulate how mines and minerals are developed and regulated in India. Second, it was an attempt for India to balance the mineral resources. Then it also the act also gives the government the authority to grant mineral concessions, which includes the prospective licensing and mining licenses for the same. In 2015, they brought about an amendment as to how mining concessions are to be allocated, which ensured like a transparent and a fair use of these resources. Further, in 2016, they spoke about auctioning. And again, this was something where they said there were a lot of cartels and, a lot of non-transparent movements that was happening. So just to ensure that that was kind of moved away, they brought about this amendment for transparency, encouraging mergers and acquisitions within the mining sector, and also trying to build this particular business to promote efficiency and sustainability. Then in 2021, you see that the government has given the owners the freedom to use the minerals and harvest it the way they wanted. And in 2023, the central government has been given mineral concession for critical minerals, keeping in mind their importance. So you see that even before 2025 mission came in 2023, they did add in an amendment to the Mines and Minerals Act of 1957 to ensure that critical minerals were being included into the resource management in India. So apart from that, we also have the laws governing critical mineral resources with respect to offshore areas minerals, which is with respect to the ocean mining. And that's something that's been getting a lot of trajectory of late. And what they look at over here is basically with respect to looking at exploration and extraction and different kinds of operational rights and based on the offshore mineral development. Further, you will see in 2023, they've had amendment which is brought out with respect to the grant of mineral rights. So again, all of this kind of goes back to your aspect of commons and how with the government intervention or your public trust doctrine, considering that India used the public trust doctrine through the judicial decision in MC Mehta versus Kamal Nath. Again, we borrowed it from the US decision of the Odd Bond Society's case, where we say that if it is a national resources or it's a commons, then it is the government which would act as a trustee on behalf of the citizen for the welfare of its citizens. So further, okay, I have a minute. I will try and quickly wrap up with the key pointers there. So when we talk about the governance and management of critical resources, we see three main policies, acts that's there in place. One is the National Critical Mineral Mission 2025, which came in off late in January 29th. Then you have the Mines and Minerals Act, which was amended to include in 2023 even critical mineral resources. And then you have the Offshore Area Mineral Development and Regulation Act. Further, rules for exploration and production in specific, you have in 2023, where they have mentioned about introduction of licensing for exploration. The constitutional and jurisprudential aspect, I think Jai Batro already discussed about the constitutional safeguards. But those of you who are interested, if you could just look at this decision in 2024, where the courts have looked at whether the owner has a legally recognized right to receive royalties or other comparable payments in exchange for the extraction of minerals have been determined in the affirmative. So this was one of the first cases where they actually looked into this particular aspect. So probably if you could just go through this, you will get a better understanding of how the judiciary has actually stepped in when the laws are kind of not very clear on the aspect of the resources management. Then when you look at liability structure for abuse and misuse, we do see that the mining companies are required to contribute certain funds for the development and welfare for the local communities. When Sir was talking about biological resources, I think when Raghav and all of us were working on the UNDP project, they did talk about access and benefit sharing, wherein that was one of the mandate under the Nagoya Protocol, which India is also part to. So similarly, with respect to mining companies also, they do have a provision wherein they have to contribute towards the local communities which are impacted by the mining. And also at the same time, they would be addressing the social and environmental consequences. But the next question is, how far has it been met with? That is a huge question before us. Now, sovereignty over national resources and energy security. I think the Australian bill as well as the Canadian laws do mention about how at the international front, the sovereignty should be given to states. In India in specific, you do have emphasis of energy security, which is mentioned in the National Critical Mineral Mission and the Offshore Areas Minerals Act of 2002. I think with that, I will stop. I took a minute. I'm so sorry. But if anybody has any queries, please do feel free to put it out in the box. I'll be more than happy to address the queries. And thank you so much for this opportunity. I will hand it over to Jai Batro. Thank you so much.
Thank you, Dr. Vidya, for your insights on critical mineral resources and providing a detailed presentation with regards to the same. Next, I would like to call upon Dr. Gayatri D. Naik, Assistant Professor, NLSIU. Ma'am, over to you.
Thank you, Jay. Am I audible?
Yes, yes. Properly visible as well.
Okay. Thank you, sir, for this wonderful opportunity. I'm glad to join you all today. Can I just have the access to share my screen?
Ma'am, you have the right.
Yeah, right.
Thank you.
I hope my slides are visible.
They are.
I'm slightly moving away from what my previous speakers have discussed. I'll be more focusing on the water sector, which is my specialization, on which I've completed my PhD, and I'm just trying to interlink with my co-author the questions of property rights, which comes up as a challenge with regard to India's water management as well as the coastal resource management, or or at least the overall environmental governance. So the title which I propose for this is the intersections of the questions of property rights and the need for resource protection in India's water and coastal resource management. So I'm just trying to look this aspect of intersections of property rights and what are its implications in environmental governance from two different aspects. One is with regard to the groundwater management, and the second one is with regard to the coastal resource management, that is CEERA notifications. I'll be very quick. As you know, this environmental degradation is equally a global as well as a local concern. And the way we have approached this various international or national environmental issues have been a little bit diverse from two different perspectives. If you look into the international environmental law perspective, major question that comes up as a challenge for environmental protection is how we can balance this sovereignty rights, that is a permanent sovereignty over natural resources, or the question is between this permanent sovereignty over natural resources versus environmental protection, or to bring a global consensus on the environmental protection, for which we have tried to put forth these aspects like common heritage principle, common concern of mankind principle, etc., to at least to bring a balance between these two conflicting questions. But when it comes to the domestic aspect, instead of about, okay, one of the way it is also trying to talk about the sovereignty, but it's more or less about the question that comes up between how we can assure the property rights or how the property rights are regulated. And then at the same time, we are also assuring the environmental protection for the common good of the community as such. So whenever you see this domestic environmental framework, and when the state is trying to regulate environmental or the management of natural resources or to assure environmental protection, always the question comes up, or at least the argument comes up is, I have the right to use property, even though that's not a fundamental right now in India, but it is a legal right. And also how we can balance the fundamental right to freedom, like freedom, right to trade, business, etc., and also how it is to be reconciled with another fundamental right, which is the right to clean environment, which is protected under Article 21, right to life. So these questions are what I'm trying to bring up in this paper. So broadly, I'm just trying to figure out why these questions comes up in India with regard to these intersections of property rights as well as environmental protection issues, because it springs from the very basic aspect that in Indian context, environmental governance is pluralistic with influence of statutes, rules, administrative directions, and the judicial decisions. As we all know, right to clean environment, as we highlight as a fundamental right, is a judicially carved right from Article 21 of the Constitution of India. So if you see this, the difference between the approach that the statutes and the judicial decisions follow is statutes lack a right-based approach, but instead and also a precautionary principle or precautionary approach, but instead they follow the command and control control approach with more focus on pollution regulation, and also to bring about the regulatory aspects like constituting certain regulatory frameworks for so and so matters. But the judicial decisions, if you look into it, is based on the principles of international environmental ethics, imbibing the spirit of international environmental principles in the Indian context, and also highlighting this rights-duty approach for the environmental governance or resource management, particularly if you look into the aspect of right to clean environment, right to water, which are the two sectors which is highly enriched from this rights-based approach, which unfortunately has not been reflected in any of the statutes or administrative directions, which is currently in India. So that's why this ambiguity, wherein one organ of the government, the judiciary, focusing on this right-based approach, and which the executive nor the legislature doesn't follow. I mean, the other two sectors hesitate to follow this rights-based approach. As always, this concerns how we can balance balance between the different rights, and how can we address the conflicts over conflicts arising from various rights, like right to property, right to freedom of trade and business, versus right to environment. So just let me just start with the aspects of property rights and why we need to address this property rights when it comes to the environmental governance, because one of the aspects is that the private property rights, as we recognize now, is always creating certain inequity and non-inclusiveness in accessing the natural resources. So when you see this property from a theoretical perspective, both from the bundle of rights concept, when I have the private property rights, I have the entire bundle of rights, including access, withdrawal, management, exclusion, and transfer. But if you move beyond this bundle of rights concept of property and bring in then some element of value theory of property, which says that this institution of property is being created or designed to create and defend the value that inheres in a stable ownership, when the state comes and steps in to restrict my private property, even though in the form of or with the objective of environmental protection, it is actually interfering in my private property rights. So it's actually reducing the value which the private property as for an owner like me or anyone has. So how we can reconcile this one? Because on one side, the law protects my private property, but at the same time, in the form of a reasonable restriction, the state steps in saying that for the common good, I have to restrict your property rights because environment is something that requires more protection than your property rights. So the question that basically comes is, can this property rights, which is also a legal right, which is assured and protected by law, be restricted for the environmental concerns? And if so, how can we bring a balance between assuring the property rights as well as at the same time protecting and assuring environmental protection, not only for the present generation, but also for the future generation? So like I said, property rights has always been inequitable. And one of the sector which you can see the negative impacts of the property rights in accessing and allocating the natural resources is a common example of groundwater governance, where we follow this land-water nexus-based regulatory framework, which actually allows the landlords only to access. If you look into the legal interpretation of common law framework-based groundwater regulation, it actually allows only the landlords or the landowners to access the water resources beneath their property or land. But at the same time, if you look into the statistics, which is in India, this land ownership or the property rights is inequitable, which is skewed towards the upper caste people, particularly men. Then there are concerns about the social, economic disparities and historical discriminations based on the social and economic factors being widened and reflected in accessing such a very important and critical resources like groundwater, which is itself sustaining the life as well as livelihood of millions, supporting the food and water security of this country. And when right to water is a fundamental right, being upheld by the judiciary, on the other hand, the real situation, particularly with regard to the groundwater, is that how can we assure this fundamental right to water in a context when the major water resources for the majority sections of the population, being groundwater, is regulated by this property-based or property rights-based regulatory framework? So someone can ask me why don't we have a regulatory framework like statutes? Of course, we have statutes for groundwater regulation, but unfortunately, these regulatory framework in the form of statutes also follow a command and control approach by grandfathering the existing regulatory framework. That is, it has not touched this property rights aspect in groundwater, which results in inequity and non-inclusiveness in accessing and allocating this natural resources like groundwater. And at the same time, the lack of procedural justice, like right to participate in decision making for the sector or for the water users, is also leading to this inequity in accessing this natural resources, particularly when it is regulated by the property rights. So this is one of the sector where we are articulating that the property rights-based regulatory framework of natural resources should be delinked and be replaced by some other framework. And one of the framework which is suggested for delinking this land-water nexus is public trust doctrine by most of the scholars. But unfortunately, if you look into the understanding, jurisprudential understanding of public trust doctrine also works on the property rights framework itself. The only change that they can bring is to change or to take this private property-based regulatory framework to make the state as a trustee. But the inherent aspects of property-based regulation still exist in public trust doctrine, which will not be sufficient for regulating groundwater and addressing the groundwater exploitation in the long term to assure both supply sustainability as well as the source sustainability for the present as well as the future generation. So this is one of the sector where we are trying to figure out the negative aspects of the property rights and the need for moving from the property rights to bring a governance framework which is completely beyond the property-based aspect to assure a framework which can be based on understanding of water as commons, and thereby we can bring equity and inclusiveness in access, allocation, and governance of water resources. But there is another sector, particularly in the case of the coastal areas, where the state has tried to address this property concerns and has successfully brought in this aspect of environmental governance in more predominant stage over the concerns of property rights claimed by the people who are living on the coast, as well as the need for regulating the use of property to bring more coherent environmental framework. So this is just an opposite when in one case, when groundwater governance is based on property rights and the state is unable to figure out a solution for delinking this property rights. In CEERA, we can see the opposite, wherein the state is trying to figure out, or state has successfully, or at least to an extent, successfully tried to balance its property rights plus with the environmental concerns. So more or less, in more cases that we are addressing through, or we are seeing what we can see through the judicial decisions, environmental factors have overridden the concerns of, or the concerns of the property owners, and environmental concerns has been successfully kept at a top level over the property rights claimed by the property owners. So, as you know, the coastal zone regulation notifications brought under the 1986 Environmental Protection Act, right, from 1991, 2011 or 2019 version, tries to maintain like three aspects. One is zoning, regulation, as well as at the same time trying to provide some conservation in the form of prohibition and regulation of permitted and non-permitted activities in the coastal areas of the country. So when it comes to the CEERA, basically two questions comes up. One is the question of a uniform pattern articulated by the central government over the state's ambit of, let's say, the state listed entries like fisheries or regulating certain industries. But successfully, the judiciary has set for the broader environmental concerns of assuring the broader environmental protection issues. These regulations are very much important. So that is now settled. But the second and more important concerns when it comes to this coastal zone management is about how this private property owners' rights are restricted by the state regulation in the form of coastal zone. If I'm running out of time, I will be very quick in concluding. The question itself is, when I have a property right, which I get by, let's say, a private dealership, why the state should come in and regulate my private property rights in the form of coastal zone regulation notifications. This is almost the questions that we can see in all the decisions relating to the CEERA notifications, and how the judiciary has tried to address this is what we have to analyze to get an understanding about the intersections of property rights and the environmental concerns in the coastal zone protection. There are a lot of cases where this concerns of property rights versus environmental governance has come up with regard to the coastal zone regulation implementation. Three of the famous cases most of you will know is the Swamik Island case, DLF case, and Maradu municipality cases, which curiously happens to be from the same state of Kerala, from where I also happen to hail from. So here the questions about when you have the private property rights, when you have the right to enjoy the property rights, when the property rights give you the value, can the state step in or can the state regulate your property rights, even though when the state is at fault due to some of their regulatory failures? So this was the questions that came up throughout these cases. And one or the other way, this judiciary has tried to put forth this the need to regulate private property rights. And these are some of the examples where we can say that private property right, the state regulation for the broader environmental protection is a way to regulate the private property rights. So in this way, in India, if you look into completely from the jurisprudential aspect of the property rights theory, we have not imbibed the concept of value-based theory of property, where we are providing or we are allowing the private property owners to enjoy the value of the property which they actually own. This is a small difference. There's a small difference from what our concept is when we compare it to the concepts like how the coastal zone managements or the property rights concerns are being addressed in countries like US, particularly through the examples of Lucas, where the court has tried to address the value-based approach to property. And there should be a justification for the state to acquire your private property rights and how that can be reimbursed by not compromising the right of the private property owners. But unfortunately, in Indian context, without any jurisprudential analysis of the property rights or the property theories, we have just focused on highlighting the environmental governance over the private property rights. And this has been successfully done, at least in case of CEERA or the coastal zone management. So what I try to put forth or with my co-author in this paper is that in some cases, in Indian context, private property rights have been, or the state has been able to regulate the private property rights, to taking the example of CEERA, but unfortunately, in a very important sector like groundwater, we haven't been successful to address this inequitable and non-inclusive access and allocation issues, which requires more address on the property rights. And it's a high time to move beyond this property rights aspects of regulation to address at least the climate change impacts right now, which we are facing throughout the country. So what we need, and the takeaway which I try to propose in this paper is, it's not that we can completely move away from this property, the intersection between property and environment. The question always will remain, but what we need is a balanced approach, more sustainable, more inclusive, more equitable and harmonized approach, where we can equally balance the rights and needs of human beings along with the rights and needs of natural resources like water bodies. So right now we have this concept of right to nature. So we need to think how this right to nature, which is now implemented through granting the legal personality to water bodies, the Himalayan glaciers, etc., that we are now articulating, how we can create a frame to implement it in the governance framework. That's what I would like to speak about. If you have any suggestions, if you have any comments, please feel free to share.
Thank you, ma'am. Thank you, ma'am. Thank you so much for making this detailed presentation and taking through us taking all of us through the critical aspect of private rights and the natural resource sector, especially in the water sector and the coastal zone regulation zone. Thank you, ma'am. Friends, for the next is Lan Alnisha and they. She will take us through her work on the. I'm over to you.
Thank you so much. Nabila, I request you to begin, please.
So a very good evening, everyone. I and Dr. Mrinalini, Nabila and Dr. Mrinalini would like to have a discussion today on a very theoretical aspect of whatever we've been discussing. So today we would like to discuss upon the legal pathways to equitable land, soil, and water resources governance in India. So of course, we'll be dealing into these three most important sectors that are there. And very interestingly, we will also try to criticize the current legal framework and institutions that are very much prevalent in India. Apart from that, we will also look into the solution and the pathways for a model future and environmental justice oriented policy making and legal framework that would suffice in India. So it's a more regional Indian oriented discussion that we're going to have today, though we would also look into the best practices that are prevalent in other jurisdictions and try to incorporate in the discussion today. So what we've tried to do, Dr. Mrinalini and I, we've tried to bifurcate the discussion into a few headings. And first, we would try to look into why natural resources is important, of course. And then the discussion will go on forward by looking into one of the famous works of Professor Singh in 2023 in Environmental Justice and Commons in India, where they've looked into two important theoretical frameworks, that is the theory of tragedy of commons and then the theory of commons theory that is there. So the tragedy of commons theory is a more pessimistic theory, inclining towards the economical analysis and economical understanding of natural resource management, whereas a commons theory is a more legally and policy oriented theory, which gives a more solution oriented policy making and legal framework. So I think now I would like to invite Dr. Mrinalini to take over and throw open the discussion by founding our discussion on theoretical framework, the legal structure, and then I can take it forward through the solutions that we propose to welcome in this discussion. Over to you, Dr. Mrinalini.
Thank you so much, Nabila. So as Nabila has already laid down the structure of our entire discussion for today, so I would start with introducing why is natural resources so important. So the natural resources which we will be covering are land, soil, and water, and they are central to India's socio-economic and ecological well-being. And we all agree and we know that the population of India is exceeding, which is 1.4 billion, and India being an agrarian-based economy, the equitable use of resources is vital for sustainability, livelihood, security, and social justice. However, this is very idealistic in nature. Are we facing the same? No, we are not. There is inequitable access, unsustainable exploitation, and fragmented governance mechanism, which has led to resources degradation and socio-environmental conflicts. With this, we would like to highlight the 2023 UNEP report on inclusive environmental governance, which underscores the relevance of community-centric resource management in developing countries, where it reinforces and signifies on Ostrom's framework in India's centralized governance debate. While we are talking about the legal pathway and on the three main criteria which we were discussing, it is of utmost necessity that we discuss on the theory of tragedy of commons. So coming to the discussion on the tragedy of commons, I would like to provide you a brief background on the same. What is it? It was actually originally described by ecologist Grad Hardem in 1968. And the tragedy of common occurs when individuals acting in their own self-interest overexploit a shared resource, ultimately depleting it, even though if no one long-term interest persists. So it's a metaphorical term, and it was titled of a 1968 essay in which Professor Harding himself said that this concept itself did not originate with Harding, but rather extend back to the classical antiquity, which was been discussed by Aristotle. Coming to this concept to our topic in the Indian context, if we look into, in India, the tragedy of commons is deeply linked to how natural resources like land, soil, and water are managed, which are often collectively used by poorly governed, lead to degradation, inequality, and conflict. In which what me and Nabila have done, we divided it into separate headings. So the number one which we discuss about is the common property resources in India. For example, grazing of land, forest, water bodies, village commons. There has been rural communities who depend, and their lifestyle is completely depend on this livelihood. For example, the fodder, the fuel wood, water, etc. But due to open access and weak governance, they are overused and degradation. Coming to the different another heading, which is the land and soil degradation. As I discussed earlier about open grazing and deforestation on common lands, it leads to soil erosion, loss of fertility. There is no clear ownership or responsibility, means no incentive to conserve them. According to various reports, which we have recently gone through as a review of literature of our study, over 30% of India's land is degraded, partly due to its overuse of common lands. Now coming to another heading, the water resource mismanagement. Coming to groundwater, though technically a private resource under the land ownership is often treated as a common good. However, excessive extradition by wealthy farmers, especially where electricity is subsidized, leads to aquifer depletion. Poor and marginal farmers suffer a water becomes scarce or inexpensive or totally expensive in nature. So where we see a disparity again. Come to the equity issue, where marginalized groups often have limited access to common resources. Even though common are shared, the power dynamics mean not everyone benefited equally. And this is where the tragedy of common in India is not just ecological, but is also social and economic in nature. While discussing the concept on the theory of tragedy of commons in India, it is not just about resource overuse. It is about inequality, inequity, exclusion, and lack of long-term planning. And equitable governance means what? Four important criteria: recognizing community rights, empowering local institutions, ensuring fair access and participation, balancing environmental sustainability and social justice. Just to give a contrast to this theory, we have Eleanor Ostrom's common theory, which offers an empirical grounded challenge to Hardin's assumptions. Ostrom argues the communities are capable of managing common pool resources effectively, provided certain design principles are met, such as clearly defined boundaries, collective choice arrangements, monitoring, graduated sanctions, and conflict resolution mechanisms. This perspective aligns closely with several Indian experiences of centralized resource management, including Jal Panchayats in Gujarat, forest management communities under the Forest Rights Act, and the traditional tank irrigation system in southern India. Ostrom's theory provides a normative and practical foundation for advocating community-centric and participatory governance models, specifically in contexts where state interventions are either absent or exclusionary. Hence, while we are discussing on this legal pathway on the three major natural resources, employing both the theories of Harding and Ostrom, we will understand India's resource governance within a tension between regulatory failure and participatory potential, where Harding helps to explain the failures of fragmented and soiled governance, where the tragedy of overuse is a real threat. In contrary, Ostrom opens up to the possibility of reform through institutional innovation, customary right recognition, and collective stewardship. This theory also provides a critical lens for evaluating the India's legal system normative gaps. For example, the inadequacy of one-size-fits-all regulation, the marginalized of local knowledge, and the challenges of balancing development, equity, and sustainability. Coming to the recent highlight when we talk about this theory, looking into the study by Chaudhary and Rao in 2023, which provides an empirical study, it states that how water users associations in Andhra Pradesh have effectively reduced groundwater depletion, offering a real-world application of Ostrom's principle, which is commendable if we see, and I think the practice can be also continued in other places. Now, coming to my second part of today's discussion, looking into the legal framework governing natural resources in India, I'll look into the central legislations, I'll look into the state legislations, and then the secondary legislations and the policy guidelines. While coming to the central legislation, the renowned ones which have worked fantastically over the years are, for example, the Environmental Protection Act 1986, the Land Acquisition, Rehabilitation and Resettlement Act of 2013, Biological Diversity Act 2002, the River Boards Act 1956, the Interstate Water Disputes Act of 1956, and the National Water Policy of the 2012. Now, going into detail and providing a brief understanding about these legislations, the central legal regime for natural resources provide various understanding and various aspects of environmental, where we have looked into only the land use, water, and the soil aspects. Coming to the EPA Act of 1986, as we all know, it serves as an umbrella legislation. What does it do? It empowers the central government to take measures for environmental protection. It is one of the most comprehensive legislation enacted in India for the protection and improvement of the environment. It plays a crucial role in the conservation and management of natural resources. Now, moving towards the Forest Conservation Act of 1980, it restricts the diversion of forest lands for non-forest purposes and mandates central approval for such activities. Coming to in brief about the core provisions of this act, it looks into the restriction on diversion of forest act, and the main clause of this act is number of forest land or portion thereof can be used for non-purpose forest purposes, for example, agriculture, mining, industries, tourism, construction, so on and so forth, without the approval of the central government. And lastly, coming to the non-forest purpose, any activity that does not relate to conservation, afforestation, wildlife protection, or forest management. Moving on to the Land Acquisition and Rehabilitation and Resettlement Act of 2013, it's an attempt to balance the development need with inequity in land compensation, while the Biological Diversity Act 2002 fosters conservation through local knowledge and looking into the principle of access and benefit sharing. For water governance, the River Boards Act 1956 and the Interstate Water Dispute Act 1956, though remains operative, we must say that it is outdated in nature. Lastly, coming to the National Water Policy 2012, it advocates for integrated water resource management, where prioritizing drinking water and ecological needs, though it lacks binding force, but it is one of the finest policy which we can find so far, so forth. Now, coming to our recent highlight on this aspect, we see the 2021 Parliamentary Standing Committee report on the effective utilization of water resources, which critiques outdated laws and recommends revisiting the River Board Act for contemporary climate resilient water governance. So now moving towards the state legislation, we see that states have enacted resources specific laws responding to regional, ecological, cultural, and political context. Some of the examples are the Tamil Nadu's Groundwater Development and Management Act of 2003, Maharashtra's Water Resources Regulatory Act 2005. What does this aim to? It aims to regulate groundwater usage, promote sustainable allocation. The Rajasthan Groundwater Bill 2022 introduces water budgeting. However, discrepancies across states leads to unequal enforcement and legal pluralism. Now, coming to a case study of Maharashtra, which has pioneered volumetric practice and participatory allocation, which has been examined by the 2021 NITI Aayog report as the best practice for other states aiming for sustainable groundwater governance. The 2022 case study on the by the Center for Policy Research compares regulatory participatory account across 6 Indian states, calling for attention for legal pluralism and its impact on water equity and enforcement inconsistency. Lastly, coming to the secondary legislation and policy guidelines, we see that secondary legislation such as rules, notifications, government orders play a vital role in translating statutory principle and actionable program. For example, the EIA notification 2006, the groundwater guidelines of 2020, the draft National Law Reform Policy 2011. They are some of the examples of instruments that affect land and water governance. Lastly, coming to the legal status and enforceability of these instruments, they remain ambiguous, and that's what the challenge is and the obstacle that we are facing. However, a recent initiative by our Honorable Prime Minister Kushum and Jal Shakti Abhigyan also reflect evolving policy reforms. Coming to the third part of our discussion is on the judicial interpretations and case law analysis. I think most of the cases have already been discussed by Jay, so I would not go into details on the same, but we would provide a brief highlight on the same. The principles that we are looking into, for example, the polluter pay and the precautionary principle, came up from the landmark judgment of MC Mehta versus Union of India of 1987, which gives us a brief understanding, and it helps us as a key principle and helps us to understand as a major shift from the older fault-based liability to absolute liability, especially concerning hazardous industries. Coming to precautionary principle, which implies that if there is a risk of serious, irreversible damage to the environment, the lack of full scientific certainty shall not be used as a reason to postpone cost-effective measures to prevent environmental degradation. Wherein I would like to quote what the court said. Environmental measures by the state and the statutory authorities must anticipate, prevent, and attack the causes of environmental degradation. Moving on to the T.N. Godavarman Thirumalpad versus Union of India, 1996. It's one of the most influential environmental cases in Indian legal history. It revolutionized forest conservation and gave a new dimension to environmental governance. The Supreme Court expanded the forest conservation jurisprudence in this case study. Next, moving on to the MI Builders versus Radha Shyam Sahu 1999. It emphasized the resources like river and forest and held in trust by the state for public use. In the Karnataka Industrial Area Development Board versus the C. Kenappa 2006, the court underscored the environmental impact assessment and sustainable development. Recently, in the Meghalaya High Court Suomoto PIL of the 2022 on illegal coal mining, the Meghalaya High Court Suomoto PIL addressed the persistent illegal coal mining in the state, particularly the hazardous practice of rat hole mining. Initiated in February 2022, the court took cognizance of the media report and public outcry over the environmental degradation and safety hazards posed by unregulated mining activity. Coming to key development and court directives, we find that in this case, there was appointment of oversight authority, state compliance measures, continued illegal concerns has been taken care of. Court stances were enforced. Next, if we move on to the next case study on the Perumal Murugan versus the state of Tamil Nadu 2023, it concerns land degradation, highlighting judicial proactively, yet inconsistencies in reasoning and lack of technical land degradation highlight judicial proactivity. Internationally, decisions such as the Inter-American Court of Human Rights, ruling in the indigenous communities of the Ilhaha Konahat Association versus Argentina 2020, recognized land and water as a part of indigenous cultural identity. The Dutch Supreme Court in the Uruganda Foundation versus the Netherlands in 2019 again reaffirmed state duties to prevent environmental harm under human rights obligation. Coming to a comparative legal development, we see that the Colombian Constitutional Court in 2016 decision recognizes the Atautau River as the legal entity, echoes the Indian court's evolving jurisprudence on environmental personhood, raising questions about the justiciability of rights of nature in Indian context. As recent as the Supreme Court's 2024 ruling in Samaj Parivartan Samandhya versus the Union of India, it reiterated the public trust doctrine in the context of land allocation for industrial corridors, reinforcing judicial emphasis on intergenerational equity. So with this, I would now request Nabila to discuss on the second part of our discussion.
Thank you, Dr. Mrinalini. So as we've seen that, as Dr. Mrinalini explained that, we have a beautiful set of, judiciary trying to develop through its case laws and judicial activism and deciding a lot of cases, and also trying to give us a trend whereby it's try to ensure that, natural resource management and its conservation is managed in the most, possible ways, either through the institution or through the legal framework or through the policy framework. But nonetheless, we also see the fact that the central laws and the state laws are somewhat lacking behind, be it in terms of implementation or in terms of the fact that they are not properly understood by the public in large. So here, what we've tried to do in the discussion is that we've tried to highlight the problems, taking cue from the tragedy of commons theory, which Dr. Mrinalini highlighted. But now we try to move towards the solution oriented, ideas, which we've highlighted through the commons theory of Ostrom. So what we did when we analyzed the central laws and the state laws, and when we evaluated the governance and legal gaps in the given study and the current given literature, we understood one thing very clearly, that there is a fourfold problem. Now, when I say there is a fourfold problem, the first problem that we understood was overlapping jurisdiction. Now, when we say that there is an overlapping jurisdiction, we are trying to pinpoint here that since, the concurrent jurisdiction of the center and the state under the constitution is there, this also leads to legal ambiguities, and especially if we are talking about interstate water disputes. Very interestingly, I can give example of Kaveri River water dispute or Mullai Periyar Dam case, etc., so on and so forth. Then the second fold problem that we see in this current scenario is that the legal frameworks are very fragmented. Now, when we say that legal frameworks are fragmented, that means that the existing laws, they are dealing with land, soil, and water in silo, and they fail to reflect the interconnectedness between these elements of nature. So they all operate in different zones. They have no connection whatsoever, be it in terms of legal frameworks that are there or even the policies that are there. The third most important pressing issue that we saw while understanding all these problems through these theories was that there are implementation challenges. Implementation challenges, they are nothing but they are an outcome or an offshoot of poor enforcement. Now, when I'm saying poor enforcement, I also mean to say that there is lack of administrative capacity. There is also political interference, because when we talk about India, of course, political interference come handy because they weaken the impact of progressive legal instruments. So this is the third problem that we saw that, when we were analyzing all these legislation. The fourth problem, which was very much evident, and that is very much, it must be, spelled out at this juncture, is the equity deficit. Now, equity deficit here means that the marginalized groups, which includes perhaps, the Adivasis, the Dalits, etc., so on and so forth, the vulnerable communities or the marginalized communities, they often face exclusion. Now, when I'm saying exclusion in terms of access to land, to water, to, all these constitutional protections that you're talking about. So they remain completely at the periphery when it comes to, all these, benefits which must accrue or which must be given to them. So all of this that we're talking about is nothing but they highlight the challenges within the center and the state legislation. And that is why we club together and call them under a single umbrella as the tragedy of the commons. Now, tragedy of the commons, the reason being we are trying to equate it with the idea that it is weak governance, which actually is enabling the overuse and the degradation of the shared resources. So therefore, what is the answer to it? How do we solve this problem? The answer to it would be collective governance. And this collective governance is nothing but it has been advocated very strongly by Ostrom in the theory of commons theory. Now, commons theory, which talks about more sustainable outcomes, that has to be documented and it could be used in the future to come. So for instance, if we look at the India State of Forest Report 2023, it talks about the fact that, despite the legal protections, community engagements, or, whatever, you can think of, or the ecological indicators, etc., whatever it is there, still we need to have a collective action, a call for collective action. And this is nothing but it is reinforcing Ostrom's empirical claim that he makes in his theory. Now, recently, we also see that in 2022, NITI Aayog has issued a report very diligently. That report is called as the Resource Governance in Federal India. It reveals that how institutional fragmentation hampers the sustainability, inclusion, and calling for integrative reforms. Now, when we look at all of this, then we come to the conclusion of the discussion, that what are the recommendations that we have for, future policy and legal frameworks. So to address all of these gaps that we've, mentioned, there are few pathways that we wish to, recommend. Number one would be consolidation of legal framework. I understand it's a very difficult task, but what we believe is if we develop an integrated natural governance code, perhaps combining environmental, land, and water statutes, it will have a holistic regulation and also reflect the beautiful interconnectedness by marrying the problems and challenges along with the solution-oriented futuristic approach. The second important recommendation that we feel that we should make at this juncture is institutional strengthening. Now, when we talk about institutional strengthening, we are talking about having, a bolster capacity of agencies, maybe the Central Pollution Control Board, maybe the State Pollution Control Board, or the authorities through the funding, training, and autonomy. So there are three basic things that must be ensured to all these institutions, that is funding, training, and autonomy. The third recommendation that we wish to highlight through the discussion is community-based governance, which time and again we've been, taking a cue from Ostrom's theory. And the idea is to encourage decentralized models. For instance, in India, we have Jal Panchayats. For instance, we have the Forest Right Committee for participatory decision making. So this is nothing but in tune with Ostrom theory, and this could be extended to forest and soil conservation as well. The fourth and the most important, recommendation that we can make here is judicial reform and expertise. Now, we are advocating for creating specialized environmental benches with scientific advisors to aid adjudication, especially when you're dealing with complex climate resource litigation. And we all see that currently we are nothing in between a climate litigation regime which is happening globally, and I think India soon will be also one of the leading countries when it comes to issues like climate change, because there are a lot of things that are brewing behind the curtain. Now, fourth, very important recommendation that we wish to make here would be incorporating global best practices. Now, I don't understand, and we fail to understand why we are shying away from incorporating global best practices within the given regime. Wherever practicable and wherever operational, I think we should be in a position to incorporate global best practices. For instance, we can take lessons from New Zealand, where it has incorporated the Topua Act of 2017. It has granted legal personhood to the Wangwe River. The Ecuador has also been able to do that. And I think a lot of, rights of nature jurisprudence debates are also happening in India, which marks to be a progressive step in the right direction. The last, recommendation that we wish to, also propose is the fact that there should be equity and sustainability mainstreaming. Now, when we're talking about equity and sustainability mainstreaming, we try to say that you need to mandate equity assessment in environmental clearances. And we also propose to integrate ESG, which is called as environmental, social, and governance criteria, and all the public projects that are trying to come up and wish to be proceeded in the right direction. So if we look at, recent literature and the works that have been produced, very interestingly, the Draft National Framework for Environmental Governance 2020 2023 by India's ministry, that is the Ministry of Forest, Environment, Forest and Climate Change. It has proposed for a cross-sectoral environmental adjudication mechanism, and it also talks about an overhaul or maybe a reform in the institutional framework that could be, taken into place. Now, when we finally club together all these observations and try to, make a final remark at the end of the discussion, we feel that the governance of land, soil, and water resources in India is, of course, a critical juncture, and the legal landscape that is there, it's very expensive, very fragmented, very it has a lot of issues of inequity, implementational challenges, and therefore it is causing nothing but unsustainable and injustice practices that are there. So therefore, if we have legal consolidation and a gradual but a very strong institutional reform and a participatory governance in India, then therefore this can pave a way for more equitable and ecologically resilient resource regime that is there. So the future research, in fact, whatever we're trying to do today, the future research should actually be, be surrounded, or it should have an epicenter, which it should look into regional innovations and especially climate-induced vulnerabilities that are there and role of emerging technologies. So for instance, much of the judgments that we see today, they have failed to recognize the importance of science and tech within the legal arena, especially when we talk in the Indian sense. So therefore, it's high time that we recognize the marrying of or the embedding of science and tech within the legal regimes that are there. So therefore, the future generation should appreciate the emerging technologies, for instance, remote sensing, while you are doing natural resource management, and also community-led, commons management that is there, so that there is a resistance to unregulated use of, all these resources which are very much prevalent. So if we were to conclude, and three key takeaways from the discussion today, if I were to quickly highlight, would be that, the idea of selection of tragedy of commons and the commons theory as a theoretical framework for this discussion was grounded on the fact that we wish to talk about and we wish to look into land, soil, and water resources, natural resource management from the lens of shared, interdependent, and the very nature of all these resources that is there, which also gives rise to socio-ecological conflicts that are there. Therefore, the three most important, ideas that we wish to propagate through the discussion today, one would be relevance to resource degradation and its overuse, acknowledging it through these theories and also the given back data that is there. Second would be, we need to move beyond the state versus market orientation that we have, and we need to give prevalence to collective governance scheme as being one of the most important solutions for future research. The other important thing that we've tried to highlight within the discussion is integrating legal frameworks, having a strong institutional framework, and also making sure that there is grounding, equity, and justice whenever we are talking about resource access. Lastly, when we talk about policy and we move away from law, the implication of policy should be none other than advocation for sustainability that is there. So therefore, taking cue from Austin's work, we feel that we wish to inform for a more resilient, more inclusive, and a more adaptive governance institutions and legal framework in the future to come. So I think this is how we would like to sum up the discussion today. Thank you so much to the organizers. Mrinalini, do you wish to add something here?
I think we've concluded. Thank you so much to CEERA sir for giving us the opportunity.
Thank you, Dr. Mrinalini Banerjee and Ms. Nabila Siddiqui, for the insightful presentation and the points that you brought to the table. At this point in time, before we move on to the next presentation, I would invite a few comments if there is from anyone. Professor Hunker, would you want to add any insights or any observations from the presentations that have been made so far?
Thank you, Jay. I'm not sure if I have insights. I have some observations. Hopefully they might be helpful. To all the speakers, thank you very much. Moving backward, and I should not begin with being negative, but again, in thinking about comparative law, let me start with something a bit general. If you look, for instance, to how the United States and Australia have attitudes toward climate change and energy transformation, it's drastically different than Germany. We cannot, in legal research, ignore the fact that the cultures with whom we are working differ. And how they use tools, whether they will use tools, and whether the tools can be the same depends not upon only governance by the governing, but the attitudes and practices of the governed, the people. And insofar as comparative law and what we've talked about today in so many different cultures compares these very different cultures, that must be taken into consideration. I can give you an example, two examples. One, when in 2015, Europe said it was going to look very closely at false distribution of wealth and reporting in Greece. And two of the markers it was going to look for is going to use drones to look for swimming pools and yachts for which people were not paying taxes. The response in Greece was that an industry was invented to camouflage swimming pools to look like grass. This was the attitude of Greek people toward a new norm: pay your taxes on your luxury item. It wasn't, oh, we should, it's our fair share. It was instead, hide the item. That's an attitude of a particular public. I don't think we would have that in Germany. Another example I can give you from public law is I do some work in Ethiopia, and I was having a conversation about property rights, specifically regarding environment, and addressing the court. And one of my constitutional law colleagues from Mekelle in Ethiopia interrupted me and he said, Kirk, I think you're missing a point here. If we had a property dispute, we would not go to the state courts. I said, where would you go? He said, we would go to the elders. We operate as indigenous people when it comes to family law and when it comes to environmental property rights. So therefore, this is where I come to my disagreement with Ms. Nabila Siddiqui about best practices once again. Best practices can only be best for some one thing in some one place. Essentially, they are a sense of globalization using a different word. One practice in legal practice regarding conservation of the environment cannot fit all people of the world. Transplantation, for the purpose of comparative law, is a commercial idea from private law. And we see very often with the World Trade Organization or other commercial tools, transplantation is looked upon as being useful, beneficial, positive, because it will ultimately produce a globalized market economy that looks like Europe and the United States. That's the practice for whom it is best and the practice for which it is best. Not for everybody. Best practices of the WTO do not help many other cultures of the world in that regard. So I'm very reluctant to accept the concept of best practices in that sense. Going to her colleague, Dr. Mrinalini Banerjee, though, I think did allude to the fact that we have different cultures and they need to be addressed. We could look, for instance, New Zealand was mentioned with the fact that rivers are recognized to have rights, but who represents those rights? The local Aborigines can represent the rights of the river. There are no local Aborigines in Germany. Who would represent those? If we called that a best practice, how could it be implemented when there aren't people who have that connection to the river that the people of New Zealand do? So again, I have a bit of an issue with that. Dr. Vidyan Jacob and I had a little chat that I don't think was seen by everybody in the public there. When it comes to restorative justice, and I talk very often with non-law students and non-lawyers about this, if you had an automobile accident and one party was clearly at fault, every legal system of the world would expect that you pay. The person who caused the problem pays for the problem. With the environment, the states of the world do not behave in that regard. So restorative justice asks the states to behave as if they would acknowledge simple private negligence or private intentional harm. But there has been this odd thing where the countries who are most responsible, again, the United States would be one that is most responsible, where, and I know this from working in the United States, responsible corporations are willing to pay something they call, really bad use of French, an annuity. What they mean is we will pay a certain amount to restore the problem, but we will not admit we caused the harm. They don't want to make themselves exposed to liability. It harms their bond rating. It removes them from certain tax benefits, and it creates all sorts of problems regarding public support for publicly traded corporations. So maybe restorative justice can work in a sense where money is paid. But if we're really concerned with, and I've worked with some cultures that say we're more concerned with responsible people being held responsible, then the annuity wouldn't work there either. And then going back to our practicing colleague, wonderful that we have a practicing colleague in the workshop today. When our colleague Raghava Parthasarathi mentioned to us about this structure of upstream and downstream for energy resourcing, I was reminded of the fact that Germany right now has made a big deal of getting green energy which is green hydrogen from North Africa. And they've made an international treaty with Italy to do this because Italy is physically closer. The pipeline will be shorter. Compressed hydrogen cannot be put in boats. It must be pipelined. There's the practical problem. But nowhere in that discussion was that we would reduce energy consumption. So we're going to switch fossil fuels for green energy with absolutely no legal impetus, no legal tool by which to drive down consumption. And without that, we'll just have the same problem. So there, it seems that we need some sort of transition tools to make that happen, to drive down consumption. And that I'd be interested to see if that could be brought in there. So those are my 1, 2, 3, 4 pennies. Thank you very much, Jay. That's my response.
Professor, there is a question for you in the chat box. Would you want to respond to that? Assigning responsibility, I would like to hear your views on the common but differentiated responsibility between developed and developing countries of the world.
Well, it was a clever tool for the Kyoto Protocol. I think it was an attempt to recognize precisely the sort of thing I'm talking about with a legal tool. But if we roll that back into talking about restorative justice, even with that tool, the responsible parties, the responsible, if we want to call them developed countries, didn't want to play. Didn't want to play, they didn't want to pay. At the end of the day, even with that sort of thing, we have this absurd excuse still given by the United States until China as a state, not per capita, but until China as a state reduces emissions to the point where Europe or the United States is, we, the United States, need do nothing. Any logician will tell you how foolish that sort of argument is. So I like the idea. We've tried it. Unfortunately, it failed because the attitude of the liable state parties would not support it.
Thank you, Professor. With this, we would move to session number 4 for today, and I would like to call upon and request Dr. Veena Roshan Jose and Dr. Shivendra Rahul, both assistant professors at NPTEL Nagpur, to take forward the session. Over to you, Dr. Veena and Dr. Rahul.
Thank you, Jay. Am I audible to you?
Yes, please.
All right. So good evening to one and all. And after listening to such insightful presentations for the past close to 3 hours, so we would like to present our views on the topic on which we are planning to write the chapter. This is basically on the working chapter that we are, working on. So the title that we have given is Climate Change and Renewable Energy Integration in India's Resource Management. Obviously, the ultimate idea is balancing growth and sustainability. So I would request Dr. Shivendra Rahul, my colleague, to begin with the presentation, and I'll take over after a few minutes.
Thank you so much. Thank you, Professor Bhatt and his entire team for giving us the chance to share our views on this contemporary topic. And I thank my colleague also for giving me the chance to set up the tone for my session, and then she will take over. So let me share my PPT. And if you can, Dr. Veena, if you can confirm if it is visible.
Yes, it is.
All right. So the idea of today's session is that I will be setting up the tone for this particular session. I'll be sharing a lot of data and statistics and then my colleague Dr. Veena will take over and she will share the outline of our chapter, that what we plan to do. So the topic is climate change and renewable energy integration in India's resource management, balancing growth and sustainability. So we have been discussing it for last close to 3 hours, and but still it becomes pertinent to discuss right from the beginning why climate change matters. So I'll just give a brief outline about it. The global crisis, rising temperatures, sea level rise, extreme weather, and let me put it on record. I am joining from a city of Nagpur in Maharashtra, and the temperature has raised to 46 degrees in the month of April, which is so unusual in the month of April. So 46 degrees, and the local people over here are telling us that it may touch 48 or 49 this time, and may even touch 50 also. So again, rising temperature has become a challenge, sea level rise, extreme weather. And let's talk about the Indian perspective. What risks do we see from the Indian perspective? So coastal erosion, Dr. Veena will be talking more about it. She comes from the coastal part of India, Kerala. And erratic monsoons. So in India, we are observing that the monsoon season has become quite erratic. So there is no predictability, and IMD is finding it difficult to predict anything because nothing goes as planned. And heat waves. I was already talking about from the city where I'm joining right now, Nagpur, Maharashtra. So heat waves, it rather started in the month of, by the end of February. And if you talk about the northern part of India, especially, and in the central part of India, February is considered as a kind of pleasant weather. But we started getting heat waves from the month of February only. So yes, this is how climate change is impacting us. So let's understand who are the vulnerable groups. So yes, it is impacting the farmers. It is impacting their crops, coastal communities. Like you talk about the cities like Kochi, Kerala, you talk about Chennai, you talk about Mumbai, and low income households, they are also being impacted by the climate change crisis. Indian geography and economy amplify climate change risk, threatening the livelihoods and food security. So ultimately, it is impacting the entire economical cycle also, because it is impacting the livelihoods and food security of a major chunk of the population. So why this is the reason why we need to talk about and we need to take strong actions for this climate change crisis. So let's talk about more impacts. As I told you that I will be talking more about the statistics. So climate change, how is it impacting India? So melting glaciers, it is threatening water for 750 million people. Coastal flooding, many coastal cities like Mumbai, Chennai, Kochi, and other coastal areas, they are always at the threat of being flooded, and it has become so erratic. So you get flooded at any point in time. You talk about the areas like Gopalpur in Odisha. So such areas are always at the threat of being flooded. We saw what happened in Chennai a few months ago. So agricultural loss, 10 to 40% crop decline by, so there is a prediction that by 2100, there will be close to somewhere between 10 to 40% crop decline as far as the production is concerned. And environmental and economic disruptions strain India's developments. Of course, so such economic impact is there. So it is going to impact the GDP and other economic, it is going to bring the other economic disruption in India's development. So this is how the climate change is impacting as far as the India is concerned. So we will be talking about the solution also, and Dr. Veena is going to share the outline of our chapter also. So how renewable energy is going to help India. So solar power. So India is a country where we have more than 360 out of 365 days, close to 300 plus days, we get the sunny days. So solar power has a great potential in India. Then you talk about the wind energy, 8% of the global potential. I'm sharing as I told you that I believe in sharing a lot of statistics. So I'm sharing that. And our target is that 500 gigawatts of non-fossil energy by 2030. And these renewable cut emissions reduces fossil imports and create jobs. So in this way, we are going to create a lot of jobs for the Indian population also if we go for this renewable energy which is going to give us a solution also, and it is going to provide the employment as well. Then we have a lot of challenges also to overcome. So it is easier said than done. The picture is not so goody-goody as far as we project it. So we have a lot of cost input involved in that. So it involves a lot of cost. So, and if you talk about the electricity and you talk about the energy, we have a lot of grid limitations also. Dr. Veena and I, we are sharing one paper on the energy next month in Denmark. So that is all about the energy. So India is facing a lot of challenges as far as the grid is concerned. Then we have a lot of land conflicts also here in our country, which she will be sharing once she talks about the outline of the paper. Then we have a lot of policy gaps, funding and infrastructure, which is slowing, which is creating a hindrance in India's renewable transition. So yes, as the academicians, as the policymakers, we can discuss, and such discussions are required. And I must commend Dr. Bhatt and his team that he is giving us the chance to discuss such issues on such a big platform, where it may attract the policymakers also. They can do something to have a smooth transition and make some friendly policies, which is going to help and fix the policy gaps that we have. So these are some challenges. Let's talk about a vision for the green economy. So we have to focus on research and development. So the idea is focus on hydrogen fuel, affordable storage, and we must focus on global collaboration also, and community power. So we have to take the community also, especially Odisha's tribal solar cooperatives. Innovation and inclusivity are the key to sustainable growth. So we will have to be inclusive. Now, again, this idea will be a failed idea if we keep it only up to some metro cities of India. We will have to be inclusive, because we have ample amount of sunlight, we have ample water in our country. We just need to collate, and we need to use the resources that we have in the country, like ours. So innovation and inclusivity are the keys to sustainable growth. So we'll have to be inclusive if we want the sustainable growth. And so renewable energy as the tool for sustainable development. Now I hand over to my colleague, Dr. Veena, to share the inputs, her inputs, how this chapter is going to proceed. So thank you very much. We will be taking inputs from you once our session gets over. Dr. Veena, over to you.
Thank you, Dr. Shivendra. And once again, good evening to one and all. Let me just start with one simple question. Is there anybody sitting in front of me as, listeners, who is not impacted by climate change? Is there anyone in the, audience? So I believe this is the most important aspect that we'll have to discuss, and we have been discussing the same thing. As Dr. Shivendra was referring to this, I come from the coastal city of Kerala, Cochin, and I myself witnessed 2 great floods over the past 5-6 years. So we can actually understand what exactly this climate change means. And moving from Kerala, which is a coastal state, a humid place, to the barren lands of Nagpur, I would say the central part, the central plains of India, we can actually see the kind of difference in the geography as well as the kind of change that is taking place every year. So just sharing my own experience, 4 years before when I moved to Nagpur, it was not this hot. Every year, we can actually see the kind of increase in temperature. As he was rightly pointing it out, we have already touched 45, 46 in the month of April. So it is certain that we will be touching 50 this time. Last time it was 48 point something in Nagpur. So it's like, climate change is something which is very real, which we cannot ignore. We talk about it a lot, but what is the solution? What is the way out is the question. So keeping this as a focal point, we have outlined the chapter, or we have made the chapter like this. The initial portions have been already, the parts have been already discussed by Dr. Shivendra. So we will be focusing on these areas, basically the climate change problems and challenges. I know many research, many theses have been already written. A lot of academic discussions have already happened on this topic. We ourselves have written one book on climate change crisis, and it was published last year. So there are a lot of problems, there are a lot of challenges. We know that. Now, what is the way out? What are the problems that are there? Yes, yes, I am getting a question that climate change is not being affected in Bangalore, but all the news came from Bangalore last summer was not very pleasant, I believe, because of the climate change and the number of air conditioners that are being purchased in Bangalore. I heard this kind of news from the last year. Anyway, so rising temperatures and heat waves is a reality, and the kind of monsoons that we face in India, that is also something which is unpredictable these days. So earlier it used to be very clear, like we had you know, 2 monsoons coming, and that too the date was also specified. In Kerala we used to get monsoon sharp on June 1st. Now we don't have that kind of prediction also. Every year it keeps on changing, and all these are pointing towards the same fact that it is all because of climate change. Now, climate-induced human displacements, I teach human rights also. From the human rights perspective, this is one serious concern that I always feel, which is very important. Climate-induced human displacements. We will have to move from our own homeland to other places because of the problems associated with climate alone. So it will lead to forced displacement of people, and we know that there is no legal framework so far which discusses at the international level nor at the national level, which talks about the climate refugees. I'm not very sure whether we can use the term climate refugees also. There are various terminologies that are being, you know, discussed on this particular topic. Now, the impact of climate change in India has been already discussed. And now, what is the solution? There we move on to the renewable energy. So renewable energy has a lot of potentials, as well as it has a lot of challenges also. So what exactly is that we can do with, you know, renewable energy, and how we can relate it or link it with the climate change or mitigation of climate change? So it is an important solution to mitigate climate change, and renewable energy ensures energy security as well as economic growth. There are a lot of positive sides which are associated with renewable energy. And it offers a sustainable path to reducing carbon footprints and mitigating climate change. So this is exactly what our focal point is. Can we move on to the next slide, please? Yeah. Renewable energy as a tool for sustainable development. Ultimately, our idea is to achieve sustainable development. Though we have given this particular word sustainable development, its meaning and, you know, its dimensions are so much that we cannot comprehend how important this kind of development that we talk about is in today's modern world. So we have this, you know, renewable energy which can be used for environmental sustainability. When we use the term renewable energy, it includes solar energy, wind energy, hydro energy, biomass, geothermal, all these categories of energy, which are categorized as renewable energy. And they are generally referred to as clean energy, unlike the other forms of fossil fuels, etc. And they are considered as a sustainable alternatives for the kind of. Yeah, I'll come back to your question, Niti, if it is all right. Now, we have this particular renewable energy, which will definitely reduce carbon emissions also. So it's like, you know, you have one solution, one option before you, which proves solution for many problems. And benefits of renewable energy adoption. This is also something that has been discussed all over. Like it helps in preservation or conservation of environment. It helps in economic growth and energy security. It reduces greenhouse gas emissions. So these are all the benefits of renewable energy adoption, which has been already settled position, or we know that, yes, this is what it is. Now, what is the importance of technological innovations in renewable energy? Whatever we do today, you know, we are living in such a fast paced world where everything is driven by technology. What a law and regulations, rules and regulations cannot achieve can be very quickly achieved if we try to integrate technology into our frameworks. So advancements in battery storage, smart grids, and energy efficient technologies are all, technological innovations that will help in improvising the renewable energy. And research and development in hydrogen fuel cells and offshore wind energy, etc. All of these are examples where technology will come into, help in achieving or attaining sustainability. So can we move on to the next slide, please? Now let's talk about India's legislative and policy framework for resource management. We are, we are very proactive in this way. We don't have any dearth in any laws. Like you take the example of environment protection and, we have enough and more laws. So what is that is lacking at the international level also? We can see that there are a lot of legal framework is in place, but even then we are not able to achieve, though we are in the right path. I will not say that I'm not being very pessimistic. I'm always optimistic in this way. From 1972 onwards, if you see the kind of improvisation and improvement that has happened in the conservation of environment and the understanding relating to that, we can actually say that, yes, we are improving a lot. There are certain lacunae still existing, which we can identify and we can rectify also. So India, as I told you, is very proactive in this way. We have, we are party to UNFCCC, then Kyoto Protocol, Paris Agreement, and we have also, given our NDC, the nationally determined contribution, and we named it Panchamrit. We kept 5 important points to be, materialized before 2070. We kept different targets: 2030 as a target, 2045 as a target, 2070 as a target, where we are planning or we are trying to achieve net zero. So under this nationally determined contribution that we call it as Panchamrit, we plan to achieve 500 gigawatts of non-fossil fuel energy capacity by 2030. This is one of our goals that India has put forward before the international community, that we will try to achieve this by 2030. And 2030 is just, quite near to us. We will have to work a lot in order to reach that target. And India's legislative framework for renewable energy development is also well structured, and we have a very, very, clear-cut laws and regulations that are in place. We have the Electricity Act of 2003. We have the Energy Conservation Act of 2001, very advanced in that way. And yes, of course, beyond these, legislative framework, we have policies also a lot in place, which helps the government to initiate the plans and work it accordingly. So we have the National Electricity Policy of 2005. We have the Tariff Policy of 2016. We have the National Action Plan on Climate Change way back in 2008 itself. So the policy framework as well as the legislative framework in India is robust, and we have clear regulations in place in order to how to achieve these targets, how to mitigate the problems associated with climate change, etc. So can we move on to the next slide, please? Right. Integrating renewable energy and climate adaptation strategies in India. Now, how can we bring these two things together? So on the one side, we have a very serious problem, that is climate change and the problems associated with climate change, which is very gross. As I asked, is there anybody in the, amongst us who is not impacted or affected by climate change? There will be nobody, I'm sure. So that is a serious problem, that is a great problem. And we have the solution also, that is renewable energy. Now, how to integrate these two things? This is what I studied in this particular chapter. So there are various challenges in renewable energy integration. It's not very easy as we speak, and especially developing or, in the upper ladder of the developing stage, the country we are in. So there are a lot of challenges, like policy and regulatory barriers are there. Certain laws are, difficult to implement. We are in the path of trying to make it workable. We have financial constraints. Of course, our basic, target is to feed the people, the growing population that is under that is not under control. That is basically the problem with India. So we have a lot of financial constraints and we have a lot of investment challenges also. The infrastructure and grid integration issues are also there. We have land acquisition issues, as we say that, Dr. Shivendra was also referring to this. Whenever we acquire land for any public purposes, there are a lot of legal aspects that are associated with that. A lot of land acquisition and environmental concerns are also there. And definitely the most importantly, what I believe is the technological and skill gaps that are still in place. We are not skillful enough, or we are not technologically updated, or we are not ready to reach that stage. That is the main problem that we face even today. And yes, government is also trying to initiate many programs to overcome these challenges which are posed by climate change, like financial incentives, subsidies, tax benefits. Then we try to support renewable energy adoption, like this solar energy and all. Let me just take one moment to explain about our own university, Maharashtra National Law University, where we have got the Griha 5 certification, which is considered as an environment friendly campus. We have our own, we are 100% self-sufficient with water, resources. And the kind of buildings that we have constructed, it all has a lot of, aspects related to sustainable living. Now, the programs like fast adoption and manufacturing of electronic vehicles, the FAME India, all of these incentives and policies are also being adopted and put forward by India in order to achieve or in order to integrate these two aspects of renewable energy integration into climate adaptation strategies. Can we move on to the next slide, please? Yeah. Green economy, renewable energy governance in India's climate policy. So what is that we are, what is that we want? We actually want green economy, and it's not, as I said, it is not very easy for a country like India to achieve that, but still the potential of renewable energy in shaping green economy has to be acknowledged in the first place. And there should be a lot of reforms in India's renewable energy laws and policies. Yes, we have almost all the laws, made in the recent past. But yes, as the technology improves, as the, change happens in the environment as well as climate, we'll have to make changes in our legal system also. And to accelerate the transition, India must strengthen public-private partnerships in renewable energy, invest in research and innovation, enhance international collaborations for technology transfer, and develop decentralized renewable energy solutions for rural areas. So these are the suggestions that I am putting forward to achieve this green economy. Can we move on to the next slide? Yeah. What are the solutions and future strategies for renewable energy integration? So problem is there, solution is there. Now, how we can materialize this, how we can bring in the change that we desire for. So strengthening legal and policy frameworks, I've already mentioned that. Enhancing financial incentives and investment opportunities. So only when the moment comes that we think that it is all our own responsibility, it's not just the responsibility of the government, or it's just the responsibility of the legal framework, or the international community to talk and deliberate upon climate change and its impact. When we understand and realize that it is our own responsibility to work for this, then only it starts. The beginning point would be that. Modernizing grid infrastructure, promoting research and development, and public awareness and capacity building, which I feel is the most important among all of these. We need to make people understand what they are actually going through. And we need to make people understand that, yes, climate change is a reality. It is happening during our times. We may be saved to a great extent, but the generations that are coming up may have to face the problems associated with the climate change. That is a reality that we have to make the people and public aware, and it is our responsibility to, make them understand also. Yes, coming to the last key takeaways. Integration of renewable energy is to be included in resource management laws in India. That is the only option that we have as of now, because the clock is ticking. The climate change, it's increasing in front of us. The temperature is rising in front of us. The change is very evident in front of us. So we'll have to make changes as soon as possible, and we have to integrate the renewable energy into the resource management laws in India, and definitely it will have to translate into policy and practical application. Enhancing financial incentives for integrating renewable energy and improving investment opportunities, especially when we can go for PPP, public-private partnership, in almost all the other developmental activities. Why not this? And these are the most important aspects that I've identified for dealing with issues such as climate change. And lastly, research and development and technological innovations are important to tackle the issue. So with that, I conclude my presentation. If there are any questions, yes, we can go through that.
Thank you, Dr. Rahul and Dr. Beena, for your presentation. Are there any questions from our participants at this point in time? While we have been discussing about climate change, is there any definition or a proper statement as to what is climate change? What time is it required in which generally a climate change notion is attributed to, since we have been discussing that since a lot of time? Dear participants, friends, any idea? And we have also been talking about renewable energy and how renewable energy is the future. So I somewhat feel that renewable energy is not so green in terms of energy, because it has a lot of repercussions as well in terms of the bad and side effects of the same. So what do you think, friends? Are there any side effects or the dark side of renewable energy? Can we have a few responses in the chat box? Because we have been discussing that one of the mitigation approaches to climate change is adopting to renewable energy, but how renewable and how responsible is renewable energy? So any thoughts on that front, friends? Or anyone from the panelists also, if they would want to intervene on this particular aspect. Feel free to use the chat box. The Great Indian Bustard case is a classic example of the dark side and the land requirement. Absolutely. How the Supreme Court has intervened in the same case, and how this went ahead and brought in that climate change and the adverse effect of climate change is a right that every individual must have. So the Supreme Court indeed has come forward and accepted that, yes, there is a right to stable climate for individuals as well. But now coming and taking the discussion to renewable energy, so are there any side effects of renewable energy? Because the lithium-ion batteries that are there in the EV vehicles, they're being sourced from Africa, in small mines in Africa, where children are sourced into those mines and they're mining it with the small hands and getting it. Now, again, when we use an EV vehicle, it comes with a shelf life. The battery needs to be changed every 8 to 10 years. So what are the processes that are involved in order to renew or use the same battery once again? So these are a few aspects that are still being developed. So any comments or any insights from our panel, even Dr. Veena or Dr. Rahul, if you want to intervene on the same?
So Jay,
of course. Yes.
Yes, sir.
Absolutely, absolutely right. See, there is always a dark side to anything that we do. If you talk about the developmental activities, and there are empirical evidences available, which has proven this fact, that because somebody asked this question that about the this windmill and turbine and all, yes, it is going to impact. So the developers need to keep this thing in mind in order to mitigate all those risks. They need to avoid the sensitive area. Then anything that happens, in order to balance the ecology, they need to maintain the ecological balance. So site selection, there are empirical evidences available in which they have proven this fact, that while you are installing this windmill and all, you need to be very particular about the site selection. And if the site selection is not happening in the right manner of keeping other factors in mind, you talk about the livelihood and other things. Yes, it is going to show you the negative impact, and it may be counterproductive also. So yes, we do have the dark side of it. As you talk about the nuclear energy also, You want to make the electricity out of it, or you want to make the nuclear weapon out of it. So there is always a dark side to it. Similar is the case with the renewable energy. We have, I think you were talking about the how to dispose these batteries and all. So there should be a proper mechanism. There should be laws for that. And yes, that is required.
If I may add to this, yes, definitely technology has its own advantages that we generally see. Just take the example of AI. We talk about AI almost every day. We use the help of AI in each and everything. But yes, it is something that we as human beings should control. Artificial intelligence should be controlled by human beings, not artificial intelligence should not be let to control or allowed to control the human intelligence. Okay, so similarly, there are pros and cons, definitely, but yes, and that is the reason why we have the entire system in place. I think the participant Nithi has already pointed out about EIA, Environment Impact Assessment. Yes, we have the system in place. It is all about implementing it in the right sense. We have EIA notifications. We have the entire, system that is to be followed whenever we initiate any kind of developmental activity. So that goes without saying. That doesn't even require any kind of specific mention, because that is there in our legal system already.
Absolutely. So as we propose solutions, sorry, was there anyone saying something?
Yes, Jay, I just wanted to come in here. No, I just wanted to ask the participants, how many of you think coal is a non-renewable energy or a non-renewable resource? Participants, please respond. How many of you think coal is a non-renewable resource? Please take part. It's a non-renewable resource. Yes, coal is a non-renewable resource. Okay. Okay. Can coal be a renewable resource? Not for the current generation, but for the generation sometime later on. Is it possible? Can coal be, might be, okay, millions of years and lot of pressure. Yes. Okay, Subodh has said something very important. But Subodh, what is intergeneration equity, Subodh? Is it just between me and Jay, or between Jay and someone very young? Or intergeneration equity is between us and probably the generation millions of years down the line? Yes. So, what should be our attempt? See, between renewables and non-renewables, are we just judging the resource in the current context, or should we manage the resource for future? Today, thanks to the technological inventions that are existing in the markets, please note, we may end up in also capturing carbon and using it, carbon as a resource, right? So we know of industries and startups that are actually working on the same. So I think it is the problems of nature that we are finding solutions to and working towards it. So the scientific community is actually working really hard to bring about very tangible solutions. And I think these are opportunities for legal and policy makers to actually look forward to finding these solutions and framing a legal system that will enhance the participation of these solutions as well. So I think it is something that we can always work towards, and hence when we speak about renewables and non-renewables, I just wanted to make this clarification very, very clearly that a non-renewable resource at times, and this is a future possibility, can be worked towards making renewables as well. So this is something that I had learned at the Indian Institute of Science, and I thought our participants here must very clearly understand that dynamism as well.
Thank you, sir, for the intervention. And yes, as we focus on renewables and non-renewables, it's a matter of time as to how do we see and how the solutions come on that way. Raghav, would you want to intervene out here with a few points?
Yes, in terms of the renewables, basically, I personally feel that yeah, the transition is very much required in terms of the non-renewables to the renewables. But yeah, in terms of the environmental concerns, since I mean the government objective being that it's a long-term change, it's a long-term transition, right? So such being the scenario, I think even the policy and the regulatory framework in this regard have to be has to see a transitional shift. And that will, I think, address the environmental concerns, especially the climate change issues that we are facing as of now. I mean, from the other perspective also, from the oil and gas sector that I can talk about, government has been focusing on transitioning from fossil fuel based economy to a natural gas based economy. I mean, this policy has been in place since 2016-17. Now, the consequence of this policy is that there may be a transition in terms of infrastructure. We need to have the ultimate end customers using it more, in the sense that the domestic usage of the natural gas is only for the cooking purpose as on today. Right now, if you see in European countries, the European countries have much more utility of the natural gas than what we use in our country. Now, most of the natural gas that is consumed in India is going towards the industrial purposes itself. Now, if I have to estimate the number, the rough number that I remember correctly, it's somewhere between 60 to 70% of it, the consumption of natural gas of the entire country, right? Of that 60 to 70% is going towards industrial consumption, right? So now the reason why we need to improve the consumption of natural gas is, one, because it is considered to be environmentally friendly, in the sense that there is reduced amount of emissions, like how the carbon emissions are there for coal or petroleum. There is a very negligible amount of emissions when we are burning a natural gas. So from this perspective, I think the transition requires to be very gradual and very slow, and for which I think the policies are in place, just that the infrastructure also should support it along with the domestic consumption.
Absolutely. Thank you, Raghav, for the intervention. And are there any further interventions, or we can move ahead to session 5 of today?
No, I just also wanted to lay down this emphasis of the fact that, look, let's not forget that energy and electricity, these two encompass as one of those universal obligations of the state. And hence, these resources have to be, utilized in a sustainable manner. And it's also about the historical, context of how there was energy poverty in this country, and hence the resource management has to be something that has to be focused. So from energy poverty, it is important that we achieve energy security. So this is the developmental paradigm, right? So from times when we had power cuts, from times when we used to have queues to get your cooking gas, to the fact that today there is these universal obligation service that the state is bound to give you. I think that's a very paradigm shift and social transformation that India has achieved in the last couple of years. And hence, these are certain parameters that have to be balanced between growth and sustainable use of resources.
Absolutely, sir. And these are indicators that the solutions are growing in the renewable sector as well. And we can expect things to balance out as renewable energy progresses in the future. So with this, we come to session number 5, and I would like to invite Mr. Divyanshu Priyadarshi, Assistant Professor, Department of Law, Vishwakarma University, Pune. He has also been a part of the center and has contributed largely to a lot of projects. And Mr. Vikas Gehlot, Senior Research Associate, CEERA-NLSIU. So I hand over the session to both of them. Over to you, Vikas and Divyanshu.
Thanks, Jay.
Because you are on mute. You have to unmute yourself, because.
So, hi all, and thank you, Jay, and thank you, sir, and thank you to all the participants who have been so patient to listen to us for more than 3 hours. Friends, no, to deviate from the discussion so far, just to deviate from the methodology of the discussion so far, I would like to make this session an interactive one. So I hope all of you are with me on this regard. Now, from the topic that we have is environmental rule of law and natural resource governance. A very important topic, considering the kind of discussion that we had for the past 3-4 hours. In the sessions throughout, we have identified several shortcomings of the current legal framework. And friends, is not the framework of environmental law and of natural resource governance is a very large body of law, and we are still implementing, still making out new laws and new policies in this regard. But as has been mentioned throughout, the implementation remains weak. There needs to be something done to strengthen the implementation of the law. So for that, we are going to take you through this session. But first of all, friends, let me ask you this simple question. How many of you heard this term, rule of law? So I am going to start from there. How many of you have heard this term called rule of law? Please raise your hands. Yes, sir, we have heard. Yes, sir, we have not heard. Sir, we are not sure, sir. What do you mean by this term? Okay, friends. Is our country India a rule of law country? Is our country India a rule of law country? Yes, no? Professor Jankar is here also, so I will ask Professor Jankar also, sir. Is Germany a rule of law country?
Germany says it's a rule of law country, but I can relate to you a little story. There was a very important professor of comparative law just north of here. His name is Bernhard Grossfeld, and he was once asked if China was a rule of law country. And his answer was, it's an irrelevant question.
Thank you, sir. That is exactly the point we have. Friends, each and every country, even if you ask North Korea also, each country will say that we are a rule of law country. No country in contemporary times will say that we are either a rule by law country or a rule of men country. Each country will want to state that, sir, we are a rule of law country. The structure, the edifice of rule of law country is in my country is very strong. That is the perception, that is the significance that this concept rule of law has acquired. Friends, please note, this is not a new concept. The concept of rule of law is not a new concept. It is thousands of years old. It has been discussed, debated, and deliberated upon for thousands of years. And friends, still this concept is an evergreen and ever evolving concept. It is still evolving. Its different principles are still being debated and decided. Friends, we have a report called the World Justice Project Report on Rule of Law. Now, what this report does, it highlights the contemporary principles that are considered within the rubric of rule of law. Now, what are those principles? They are, first of all, constraint on the powers of government. So, no limitations on discretionary powers, limitations on arbitrariness, absence of corruption, transparency, emphasis on fundamental rights, security, civil and criminal justice, a strong system of civil and criminal justice. These are some of the principles that have now started to be included within the framework of rule of law, and this list will go on to expanding only. Now, after this, the important question comes: what does rule of law has to do with the environment? Why are we even thinking about that? Friends, does rule of law has something to do with the environment? I think we have so many legislations. The Stockholm Convention is there, the UNFCCC is there, so many conventions, so many laws are there. Why do we need rule of law? And you are like becoming very silent now. Summary is, why do we need rule of law for the environment and especially for the natural resources? Friends, the simple answer is no. This to effectively enforcement of environment. Okay, fantastic, friends. Effective so to increase the effectiveness of the enforcement. That is a fantastic answer. Ashwant. Friends, in 1998, there was a convention called the Aarhus Convention 1998. It started to recognize the importance of certain principles when we are talking about environment governance. And what were those principles? They were public participation, access to justice, some things that are there, that are the facets of rule of law, they were starting to come in within the framework of environment. And taking this concept way forward, the United Nations Environmental Program, UNEP, and the International Union for Conservation of Nature started debating a very important question. And the question was, friends, since 1975, we have made so many laws, legislation, convention, but still the state of environment has not improved to the extent that we were expecting, or to the extent that this convention and legislation has the potential of improving the environment. That was the question that these organizations started to debate and discuss. And the answer that they came up with is that the implementation, the compliance, the enforcement of the laws and legislations that we have currently is not being done by following the principles of rule of law. That was the conclusion that these institutions come up with, and then they frame this term environmental rule of law. Now, what this term means? Friends, this term integrates the concern of the environment, the principles of the environment within the rule of law framework. It mandates that, look, your environmental laws, legislation, policies, decisions, they have to be implemented by following the principles of rule of law, including transparency, accountability, and so on and so forth. Friends, my dear friend Divyanshu will discuss what are the key principles that this concept of environmental rule of law deals with. Anshu, over to you.
Yes. Thank you, Vikas. I hope I'm audible.
Yes, you are.
All right. Thank you. And thank you to Professor Sairam Bhatt, sir, for giving me this opportunity to work with Vikas on this chapter of environmental rule of law and in natural resources governance. So, friends, as Vikas has given us the background of rule of law, and from rule of law, how did we come to environmental rule of law? Now, I just add a few figures, data for you all. So, from 1972 up till 1992, nations across the world had
Divyanshu? Okay. Friends, I think we have lost connection with Divyanshu. Just wait for 2 minutes if he comes back. Okay. He's back.
I'm sorry, I think there's some network issue at my end. Anyways, yes. So we saw that agreements were being made, discussions were taking place. However, on-ground implementation remained a problem. If you look at another data, it says that out of the 90 important goals that nations have set for themselves with regard to environmental protection, we see significant improvement in only 4 of those goals, which again goes on to show that that we are just what nations are actually doing is they are entering into discussions, making commitments. However, the on-ground reality remains the same or has maybe even degraded in certain areas. So therefore, we came with the United Nations Environment Program came out with the principle, the environmental rule of law theory. Now, these on the screen that are there, these are the core principles of environmental rule of law. So I'll be discussing with you all of these principles one by one. So now coming to the first one, just a second, that is fair, clear, and implementable environmental laws. Now it has 3 keywords over here: fair, clear, and implementable. All right. So if you're talking about fair, and what I'm going to try and do is I'm going to try and relate these to the natural resource governance. I might give some examples of environmental protection as well. However, we'll try and, because the chapter is with regard to natural resources, so we'll try and relate the examples from natural resources perspective. So when you're talking about that rules, environmental rules should be fair, what do we mean by that from natural resources perspective? Now, Professor Sairam sir had given us an example of how the coal allocation was being done, coal blocks allocation was being done. It was being done through a committee in a short meeting, and through that, eventually arbitrary methods, the government was allocating coal blocks. Now, that is not a fair mechanism. Nobody can call it as a fair mechanism. And therefore, what we tell over here is the rules that are made, they have to be fair in nature. It has to be equitable for everybody, so that all participants who want to apply or who want to get licenses for natural resources, they all should have equal access to the system. So that is one. Coming to clear rules. So often we find that governments or the legislature, they pass rules on an ad hoc basis or a need basis. Now, what happens because of that is that you have multiplicity of laws, or you have like new notifications coming out again and again, because of which the people who are supposed to be, on whom the law is going to be applied, they are not really sure which law are they supposed to be following. Because if there's multiplicity of laws and if they're not clear or if they are ambiguous, then the people who are subjected to that law, they're not really sure whether they're supposed to go ahead with this law or they're supposed to go ahead with the other law if in case there's a conflict. And lastly, when you're talking about implementable environmental laws, what it means is that, okay, it's good to have a goal for the long term for the protection of environment, sustainability, etc. But we need to have the goals have to be something that are achievable, short-term goals as well as long-term goals. We cannot have laws which are which become very, very difficult to implement. I'll give you an example with regard to biodiversity laws. But of course, we can understand how it works in natural resources as well. So, for example, there is something called as access and benefit sharing under the biological diversity laws, wherein companies are supposed to be sharing the benefits that arise from the use of biological resources with the local community. The problem arises when they have to define who is the local community. The company is ready to pay the benefit sharing, but with whom? When we say that they have to share the benefits with the people, let's say of Maharashtra, does it mean they're going to share it with all the crores of people that live in Maharashtra or in specific in a city in Pune? So it becomes very difficult when the goals are not clearly defined and the rules are not implementable in that sense. The second point is access to information, public participation, and access to justice. Now, this is very important again, friends, because whenever you are having a law, and if the public does not have enough access about the law, or they're not well informed about the law, then it can cause a lot of chaos in the society. It can cause issues later on, which can go out of hand. I'll give you the example of POSCO Steel, the issue that happened in Orissa. How many of you know about, by the way, the POSCO Steel case of Orissa? Anybody from the audience? Have you heard of the POSCO Steel case? No? Nobody? All right. So I'll just give you a little bit of background. So basically, POSCO is a Korean company, steel company, which was making a big investment in Orissa. And that time it was considered to be the largest foreign direct investment in India, somewhere around 50,000 crores or something. Now, that company, for them to operate in Orissa, the government had to acquire some 4,000 acres of land. All right. Now, of course, when the land is going to be acquired, the people, the tribal people or the local community who are living in that area, their land was going to be taken by the government. The government did not hold, clear participatory meetings with the local people. The local people were not made aware of the rights. They were not made aware of what kind of benefits could come to them through this particular project. And eventually what happened was, protests started. The government was already, the project had, you can say, the land acquisition project had already begun. The judiciary had to step in. They had to, the NGT asked for the land acquisition process to be stopped. Protests on the streets took place. Lives were lost. Many people died in that during the protests. Now, what happened? Because all of this leads to what? It leads to loss of faith in the system, in the government, and the public. If it stops respecting the laws or the system, then you're not really going to you're not going to be able to implement your laws or enforce your laws properly. You need the support of the public. So that is why we are saying that access to information has to be there. The public should be told that what is this law, what is the purpose of this law. Awareness has to be done. I think CEERA does a great job in awareness, doing awareness of many laws. There's so many projects that CEERA takes up, wherein they go and they, disseminate knowledge about new laws that are being passed by the government, right? So awareness has to be there. public participation has to be there. You have to take the public into confidence. You have to explain to the public that how this is beneficial for them, and only then will they agree to have the laws be enforced. So that is the second point. The third point, I'll come to access to justice later on because it's kind of repeated later on again. So I'll come to that later. The third one is accountability and integrity of institutions and decision makers. Now, this is very important when it comes to natural resources. Very, very important. Why? Because there are many studies which have actually proven this, that if any country has high number of natural resources, low environmental or a low rule of law, let's say, or environmental rule of law, then there's going to be high corruption. All right? Because who owns, or rather who controls, the natural resources of a country? The natural resources of a country is controlled by the government. And if the government is not going to be held accountable or is not going to be maintain integrity in its actions, then corruption is going to go high, especially in those countries which have a lot of natural resources. Because there is more to actually, there are more resources for you to sell off at lower prices, at rigged prices, right? So accountability and integrity of institutions, especially when it comes to licensing, allocation of natural resources, these are very, very important. Then the next one is clear and coordinated mandates and roles across and within institutions. This is a problem that India faces, or many of our governments we face quite often. What happens is, so when you have multiplicity of laws and you have multiplicity of where these laws are going to be implemented upon. So for example, you have laws on wetlands, you have laws on forests, and then this creates overlapping jurisdictions. Now, since there are overlapping jurisdictions, wherever it is lucrative for the implementing authority, if it is a lucrative position for them, then more and more authorities would want to have a say in that particular implementation of that particular law. But if it is not lucrative, then everybody wants to evade their responsibility. They want to run away from the responsibility. So what happens is, when you have multiplicity of laws, you find either overlapping of overlapping of jurisdictions, or you find underlapping, or rather gaps. There are gaps because many people are not because agencies may not want to intervene in such issues. So that's there. Because I have time, right? Yes. All right. Thank you. Then coming to the next point, accessible, fair, impartial, timely, and responsive adjudication. Now, this is where we'll talk about justice, as well as the justice. How is it supposed to be? It is supposed to be accessible, fair, impartial, timely is extremely important, and responsive. Now, accessible, fair, I think these are things that we understand. I'll focus on timely over here more importantly, especially again from natural resources perspective. Now, imagine if there is a company which is investing hundreds, maybe thousands of crores to get the license from the government. All right. Now, and it basically enters into a deal with the government. It gets the license for that particular to exploit that particular natural resource. And then when it has already, of course, it has taken a huge loan to to get the license. And now what happens is, when it starts the process of exploitation of the natural resource, a court order comes in and there's a stay on the particular exploitation that they're doing. Now, once there is a stay, what happens? The company can easily go bankrupt. Why? Because whenever companies are investing, they're not investing natural resources. You're not investing thousands or lakhs of rupees. You are investing in crores and maybe thousands of crores of rupees, right? And you need to get timely returns. And if there is a court order which stays the processes that you're supposed to be doing, then you're not going to be able to reap the profits or the benefits from the exploitation, because of which what is going to happen is companies may go bankrupt. We saw this in the 2G spectrum case, after, of course, it was a case of fraud, etc. But then we saw at the 2G spectrum case, after the licenses was cancelled and all, we see how many of those companies got bankrupt, or they left India, or they just left the game. And then what do we see after that? We see a monopoly sort of thing, or you can say just a duopoly in telecom sector in India. So that is again bad for the market. It is bad for the natural resources sector as well. The last 2 points, I'll quickly wrap up on the last 2 points as well. That is recognition and relationship with rights. Now, this is what they're talking about over here. These rights, they're talking about basically fundamental rights and your human rights. So environmental rule of law, your rights to environment or your rights to natural resources have a very big connection with your fundamental rights. Your fundamental right to life includes right to a clean environment, right to a healthy environment, right? Similarly, it also includes right to access to natural resources in the sense that if these natural resources are not exploited, they're not used. As Sairam had mentioned, these are resources. Resources are meant to be used. If we are not using them, then we are not going to give the country the benefit of those resources, right? And which will eventually impact the fundamental rights of the citizens. So we need to recognize the relationship of environmental rule of law as along with the fundamental rights. The last is specific criteria for interpretation of environmental law, which basically talks about the government or the legislature actually making very clear policy decisions as to what is the long-term policy and what is the short-term policy with regard to environment and with regard to the use of natural resources. If the government or the parliament, it does not frame clear policies, then the judiciary will not be able to interpret those laws in line with the parliament's agenda, right? So the judiciary will start making its own interpretations. Again, as Sir had mentioned, that the judiciary may even overstep its boundaries and may go into legislative mode, right? So to prevent that, the legislature has to give very clear policy guidelines that this is what we are expecting. And therefore, when the matter comes to the courts, the judiciary will be able to interpret the laws in line with the policy decisions of the government. So I think these are the 7 core principles of environmental rule of law with reference to natural resources. Thank you.
Thank you, Ganshu, for explaining the key principles of the environmental rule of law. Friends, due to the shortage of time, I will not go into the discussion regarding the judgments that we have, but please note, there are many Supreme Court, High Court, and the National Green Tribunal judgments that have dealt with the concept of environmental rule of law and has some linkage with the natural resource governance, especially with regard to coal, especially regard to water resources, and so on and so forth. So the Indian judiciary has now started to recognize and strengthen the environmental rule of law in the country as well through a host of successive judgments. Friends, now coming specifically to the natural resource governance, as Devanshu was mentioning, it means our work, we have looked at 4 key factors of the natural resource governance. First is exploration. The current legal and policy framework with regard to exploration of natural resources. Now, friends, we know that there are each natural resources is governed by their own laws. But here we are not looking at a specific natural resource or a specific law, but looking at the general legal and policy framework that exists with regard to exploration of natural resources and whether the law and policy is in compliance with the principles of rule of law and environmental rule of law. That is what we have looked at. For example, friends, with regard to explanation, I will ask you questions, friends. Does exploration of natural resource, is it a service? Can it be made taxable? No, the company that does the exploration activity, can they be made subject to taxation under the goods and service tax? That's a very important point that we looked at. And friends, please, another important point, can that tax be imposed retrospectively? Does rule of law permit imposition of retrospective taxes, retrospective liabilities? That is a very critical question that comes up when we look at exploration. Friends, when we are looking at the allocation of natural resource governance, there are various factors and various principles: doctrine of discovery, rule of capture, auctions, and still, friends, as Saram sir was mentioning during the session, that auction is a preferable option. It's not a rule. Before when the 2G spectrum case came, it was interpreted as the rule. Hence, friends, now when it is now not a rule but a preferable option, what is the rule here with regard to allocation? Do we have multiplicity of rules, or do we have different rules for different sector of natural resource? Or should we have a singular rule for all sector that deals with, okay, this is the principle, this is the adoption that we are going to take with regard to allocation of natural resources? Friends, very important factor with regard to exploitation. When an exploitation activity is undertaken, some terms and conditions are being laid down. And many times it found that these terms and conditions are being violated. There is some violation that can happen. The violation of the terms and conditions might be intentional, and it might be unintentional also. You might be extracting more natural resources than the license that you were given has described. So these are few factors that we have looked at when we are looking of environmental rule of law to natural resource governance. Friends, lastly, when we are conducting our analysis of the environmental rule of law and natural resource governance, we have tried to develop a framework of analysis. And this framework of analysis is, we have done the 3 E's framework. Now, what are 3 E's that we have looked at specifically? First of all, we have looked at the ease of implementation. Ease of implementation, friends. Can the authority, regulators, institutions operationalize the law and policy efficiently? Friends, please note, in many cases, but we have found in many case laws of the judiciary itself dealt by the Supreme Court, High Court, and national green tribunals, we have found that the authorities themselves are not sure how we are going to implement the law. There is a confusion within the authorities that how we are going to operationalize this section of the act, or a specific rule. So that has to be looked into. Second, friends, the second ease that we have looked at is ease of compliance. Now, friends, as Devanshi was mentioning, that when you have simpler and clear law, it becomes the compliance can become easier also. True or false? Friends, true or false? When the laws are simpler, clear, then the compliance can be easier. True or false? Fast, friend, fast. Let me ask you. True. Everyone is saying true. Friends, I will say it's not true. I will ask why. Because, friends, the simplest law we have is traffic violations. You will not drive with over 60 kilometer per hour. Very simple, very clear and very precise law. How many traffic violations we have? Friends, these are the questions that we'll look at. Okay, how can the ease of compliance be strengthened while maintaining the balance between simplicity and the technicality that comes and is associated with this comprehensive body of law? And friends, lastly, we have looked at the ease of enforcement. Now, ease of enforcement is through the law, through courts, through the judicial tribunals and the quasi-judicial mechanism, or the alternative dispute resolution mechanisms that are there to enforce that particular law. Friends, in India, the Indian judiciary is very well known of how fast how fast the Indian judiciary adjudicate disputes. So something has to be done with regard to that. How can we ensure speedy resolution of natural resources dispute? Friends, please note, lot of infrastructure work, lot of projects, and many sectors are dependent on the natural resource sector. Hence, any kind of dispute that can delay the use and the extraction of natural resource in an efficient way, that has to be looked into. So friends, with that, we will conclude our presentations. Thank you all.
Please mute, Kishan. Thank you, Mr. Vikas and Mr. Divyanshu, for giving an insight into the aspect of rule of law and the last part wherein you explain the 3 easy framework with regards to the same. And now we would move to session number 6. And I, with a lot of anticipation and privilege, invite Professor Patricia, who is a visiting fellow at the Tyndall Center for Climate Change Research at the UK and HWWA at Germany. Ma'am, thank you for joining us in spite of your busy schedule, and we would want to hear your remarks on the same. Over to you, ma'am.
Many thanks. I'm going to make a brief presentation with our PowerPoint. So the purpose of our article, we are going to make it together with a member of the Peruvian Society of Environmental Law, Carol Mora. She's not now with us because she's traveling. So we would like to present how is the structure, the protection or of the air quality protection and climate change mitigation in Peru, because I'm not sure, but we are not sure, but in the case of Peru, it apparently from the institutional structure, there is, and policies as well, there is no coordination between air pollution policies and measures and legal provisions with climate change mitigation. So that is a big problem. And despite the fact air pollution and climate change have a common origin in the energy model based on the burning of fossil fuels, such as oil, gas, and coal. So carbon dioxide is the main cause of climate change. Does not affect health directly, but it is produced alongside other air pollutants and fine particles that pollute the air. So science has demonstrated the relationship between the concentrations of these pollutants and attributable mortality and morbidity in the population of the world. So our article, it's aimed to describe the theory and the reality of the legal protection of air quality and climate in Peru. Peru is in South America, as you might know. So we will make a formal analysis of the existing regulations and institutional framework to make contracts with the actual implementation of these provisions. So the analysis of the reality will consider, among other sources, the process of evolution or regression of the national legal framework and recent citizen claims filed in an international trade process, and the judgment of the Inter-American Court of Rights of 2024 regarding the pollution caused by the metallurgical complex of La Oroya that has been regarded one of the most polluted sites in the world. So the article aims to propose some innovative solutions to achieve legal protection by scaling up towards a solid enough scheme of protection of the environmental human rights involved, sound environmental quality standards and emission limits, as well as non-regression against standards already adopted and achieved. So we have a scheme of how we will develop this article. We know that as the famous English writer Shakespeare said, that, how you say that in English, because I know it in Spanish, that being brief and not speaking so much is, or writing so much is the talent of brilliant minds. So we know we have a limit of words for the article. We will do our best for that. It's easier to write a lot instead of writing a little amount of pages, but we will do it. We will comply with it. And we look forward to submit the article by the second week of June. Hope that's okay with the organizers of this fantastic book, and we are very grateful to Professor Kirk-Juncker and all of you for considering us in the book. Many thanks.
Thank you, Professor, for your intervention. Professor Hanko, would you want to have a few remarks at this point in time?
Okay, thank you very much, Jay. Patricia, nice to see you. Thank you for
Likewise.
joining. Professor Ituregui is very modest. I'll tell the group on your behalf, Patricia, that she is or was the part of the team to negotiate the Kyoto Protocol for Peru. So both her practice history and her current research are suitable and very relevant for the project that we're embarking on here. So thank you very much for agreeing to join the project, Patricia. On our discussion this afternoon, there are a few things I would just return to. Jay, would it be my understanding then we don't have Arimolo Yegura with us? Is that correct?
Absolutely. I think
it was our understanding he would be joining, but I'm not sure why he's not with us. So I'll just finish up our day with a few remarks here then from both what Patricia has just told us and a few things we heard prior to that. I should also thank her for joining us in the morning from Peru. This is one of the nice features of conferences on the internet, is that we can span time zones. And if we do it at just the right time, as you have done from Bangalore, we can get Europe and South America both involved, and no one has to get up in the middle of the night to be present. I have to return once again to reference, I think, regarding best practices. And because this will be the third time today that I have mentioned it. I'm still concerned that we do not, working comparatively, insofar as we are, either believe, as comparative law did 128 years ago, that we can produce a one world system. That is no longer, has not been a comparative law goal for a long time, but rather to look at useful things that various cultures do relative to their own population and what we can learn for that for our population. And again, something I said when we started out 3 hours ago, I find it particularly interesting that we have this opportunity. And Saskia, if you would like to join, because there was some comments on circular economy and green economy, and Saskia Munster will be writing for Germany on our project. She might want to add that in. Is that again, I heard many references from the colleagues to US law, to things that have happened in Europe. The question I want to ask is, would we expect to hear German lawyers, US lawyers, Australian lawyers refer to Indian law? The goal of the book that Professor Sairam Bhatt and I have imagined that will be resulted from the workshop would answer that question, yes. As I said at the beginning of our time today, India is the largest democracy in the world, and like Peru, it's a biodiversity hotspot. How a culture works in a biodiversity hotspot as the largest democracy with a population that is 3 times Europe is something that must be considered for other countries looking at India. And looking at the embarrassment that is the current US environmental policy and administration, I can only hope that India takes the position of being a leader and not using comparative law to look at what other countries are doing, but rather leading the way for other countries to look at what India is doing. That would be the tone that I hope that we put on this piece of work. Insofar as that's the case, when we look to, for instance, Professor Sairam Bhatt led us very well in the opening remarks about the unfortunately necessary role of litigation when legislative bodies don't do their job. And as Professor Itiregui has just pointed out to us, there is, for instance, in Peru, not a connection between climate and air pollution made explicit in legislation. In the chat, we saw comments about whether there's going to be, or whether there is climate change effects on us, and the response was mixed, actually, but the dominant one is it affects all of us. And this sort of thing, when we spoke this afternoon, and I'm looking at my notes now, it was Dr. Veena who had said that as well. She said, of course there is, and this is connected to the immigration issue. So putting all these remarks together, in Europe, in the United States, politics right now, which may not be the case in India, are strongly against immigration. The US Americans, the second strongest political party in Germany right now, get all of their populist support from being anti-immigration. The question that is not asked, or not asked often enough, is why is there a worldwide flood of immigration? And Dr. Veena said this. It's because of climate. People don't move because it seems like it's just a good idea. My own family 150 years ago left Germany because there was no work in Germany and went to the United States. That's why people leave, not because they want to, but because they must. So the immigration issues that we have and will continue to have and will only get worse, driven by climate, must be addressed. And this is going to create necessities of understanding other cultures, not with a one-size-fits-all set of best practices, but how each culture then approaches the problems that are cultural problems. It was also mentioned, and we had very good presentations on the natural science. If you look at the Stockholm Institute in Europe, we have these planetary boundaries, and we have cross planetary boundaries at a stunning rate. What formerly took us 50 years to cross 2 boundaries caused 6 years to cross 2 more boundaries, and was required only 2 more years to cross 2 more boundaries at that point. The only one we improve on is ozone. And that was a relatively easy fix compared to the others. Yes, the planetary boundaries are driven by our knowledge of natural science, but the natural science itself is not the problem. It's what people do when given this natural science information, and that is cultural. We can't look for the dictates of natural science or economics. We can't look to only things measurable as if they will dictate what people do. And this was, I think, an important theme of our workshop today, picked up in various places, is the different reactions of different cultures compared to the reactions in India, which is our flagship for our work, must be taken into consideration. Of course, all continents are facing climate problems measured in the same way. But scientific information alone, ever since 1992 in Rio, nobody can claim the information was not available, does not change behavior. So my last remark then, Jay, and thank you for giving me a few moments, would be that we as lawyers must recognize that the natural science basis from which we make legal observations is the only part that's the same around the world. And what we do with law is different in each culture and must accommodate how that culture expects itself to work, to develop, to use law over and against the challenges of the natural world. And one size fits all best practices is not the answer for that. Thanks again.
Thank you so much, Professor, for your intervention. With this, we come almost to the end of the presentation from all our resource persons. Any observations from our attendees, from the people who attended the conference and the entire workshop? Professor Ankur, there's a question for you. I understand your logic in not comparing one system against the other, but as a global citizenry, how does one then come together to mitigate climate issues? Mr. Subodh is asking this question. Would you want to answer?
I can give it a try. And if I recall, it might have been Mr. Subodh who also asked the earlier today, or raised the question about common but differentiated responsibility. Because that is part of the answer to the question there. People do need to come together. You have the embarrassing situation in the United States where the leader of the country actually denies climate change, says it's a Chinese conspiracy. That has to be changed, and that's not going to be changed with scientific information. So insofar as that is needed, and that is the case, coming together to mitigate issues, unfortunately, means that progressive advanced thinkers need to acknowledge they have to work with somebody who thinks like that. That's difficult. You're not going to convince him or his supporters of the facts of science demanding change. Something else will need to be done. This is why I mentioned earlier this idea about inluities. I know that the US American mentality will accept that corporations will pay so long as they're not required to say they're responsible. Maybe for a country like Saudi Arabia, the United States, to some lesser degree, Australia, perhaps China, they would be willing to come together and pay if they're not required to say we're the cause of the problem. It is a difficult issue, but it is the issue. Getting more information to people is not going to change their behavior. We've had 30 years of that experience, and we have little progress to show for it.
Absolutely. Professor Patricia, do you have anything to add? Your hand is raised up.
Yes, I think it's so special that this book is led by India, because as Professor Juncker said, is the biggest democracy in the world, and the whole world agrees that India is like a country that is famous for its spirituality and moral values, the ethical part of what we are needing now. So actually, I just wanted to make a quick comment that the ethical part of what's going on in the whole world, despite the fact that one of the biggest countries in the world is going to withdraw the Paris Agreement, for example, it doesn't mean that the others will do it or that we will not comply with it. So actually applying ethical values, and I think Gandhi was saying something like this, is you have to do or to be the world you want to see. So despite the fact that other countries, being very big or not, are doing or going in the wrong way, the rest of the countries, we should keep the right track and keep going. Now, I don't know whether my English today is very good, but that's my my message I wanted to put across. Thank you.
You, Professor. Dear participants, any insights, any observations from your end that you would want to share with us? Anything based on the discussions, you feel free to use the chat box. Mr. Subodhias, be the change that you want to see in the world. I think that is exactly what Professor Hunker was also trying to convey when they were talking about the best practices that should be adopted, and he has been quite critical about the same, that best practices should not be the way forward. Every country is different in its geography, in the way its the landscape and the natural resources are placed. So that is something that we must keep in mind as going forward. Anything else from anyone? So with this, I think we come to the end of the workshop on critical natural resources. Nidhi, with all the attention on US stance on climate change and fossils, fortunately for the Global South to step in. Absolutely, absolutely. That has been the discussion that Professor Hunker has been guiding and focusing towards today. So based on all of these responses, with this, let's come to the end of the workshop on critical natural resources, exploitation policy. While we saw authors and a lot of individuals, the resource persons coming in with a lot of insights, beginning with Professor Sairam Bhatt and Professor Hunker laying the background of today's workshop and why is it relevant in the current global setup that we are in. So I, on behalf of everyone, NPTEL, CEERA-NLSIU, and Professor Sairam, thank everyone for their presence in the workshop, beginning with Professor Hunker and Professor Patricia, who took a lot of time out of their busy schedules and made it a point to be with us throughout the entire workshop. A special thank you to Professor Hunker, who is also an editor of the book that we are coming out with, beginning with Raghav, Dr. Vidya, Dr. Gayatri, Mr. Sanjay, Dr. Mrinalini, then Ms. Nabila, Dr. Veena Roshan, Dr. Shivendra Rahul, Mr. Vikas, who is my esteemed colleague at the center, Mr. Divyanshu, all of which, and of course, Ms. Gayatri Girish, who has been at the forefront of this entire workshop and handled and anchored the entire workshop. So thank you everyone for being a part of this workshop. And of course, the participants, we have a lot of insights that we gathered from the workshop, especially beginning with how natural resources should be governed, what kind of roles different players must play, and how the judiciary has been at the forefront and doing a major part out here, wherein the governance should have come from the legislature and the executive for execution, but that has not been the reality, at least in India as of now. So we need to see how the third generation of natural resource governance models in India and across the world as well, and also about the conflicts and how do we try to undermine these conflicts, what becomes the eventual scenario in which we are trying to resolve all these conflicts. And of course, the very important intervention of Professor Hunker with regards to the cultural dimension of each and every country and why a comparative best practices should not be the way forward. So that is something that we would keep in mind while the central theme of the book is based on the comparative perspective. But yes, that would remain a central theme as we move forward. And yes, India must lead as an example. Sorry, absolutely, Professor Patricia. Please, thank you. So with this, how India leads the future in natural resource governance in all the way, and how other countries follow and see this as an opportunity is something that we would see in the years to come. So thank you everyone for being a part of the workshop once again. Especially Mr. Sikia and Mr. Fabian as well, will be in constant touch with regards to the correspondence of the book. I'm sorry, I do not see during the beginning of the workshop. So thank you so much for being a part and for assisting us in completing this entire project. To all the participants, you'll be sent a link for a short Q&A that is developed as a part of this workshop. Kindly fill the Q&A. It's basically a short MCQ of 25 questions that we have developed on the basis of whatever discussions we have held in this particular workshop. Post that, NPTEL will be sending the certificates to each of the registered participants of the workshop. Thank you everyone once again. Could I request everyone to please turn on the videos if we could have one group picture together? So let's wait for a couple of seconds. I'll wait everyone to please turn on their videos.
Friends, and last but not the least, I would like to thank Mr. Jayabatraga Mohanta, who has been coordinating, with all of us, with the participants, with the speakers, with the authors, and also with the NPTEL team for the successful organization of this workshop. It is because of his hard efforts, and the effective coordination and organization that he had, that we were able to successfully complete the workshop on time and and effectively also. So I would request all of you to please join me in thanking Mr. Jay Badruganta also. Thank you, Jay.
That's what partners in crime do. So thank you, Vikas, for giving that. Can I request everyone to please turn their video for a short picture that we can have? Smile, everyone. So thank you everyone for being the NPTEL team will reach out to you in case of anything. And in case there are certain correspondence you want from our end, feel free to reach out to me. The email ID, I'll just put it out here in case it's not there. Yes. Thank you, Professor Hunker, once again, Mr. Sikia and Fabian, and all the participants of the workshop. Thank you, everyone.
Okay. Thank you.
Thank you, sir.
Thank you, sir.